That's okay. We have this almost every day, twice a day. This is file number 251797LT. It's entitled Carrington Mortgage versus Carrie Hale. Attorney James McCardle is here for the plaintiff, and Carrie Hale is here by Zoom with no picture, but she is here. We were here last Friday, September 12th. This is a foreclosure action. The defendant indicated she was having a difficult time finding a place to move to, but hoped to move by the end of the month. So I continued the matter until today, which is the 19th of September. Ms. Hale, have you had any luck finding a place to move to?
No, sir. I was going to move in with my daughter, and then they were served with eviction too because they go month to month.
Mr. McCardle, do you have any discretion in this case?
I do, Your Honor. In fact, I could, if we could enter into a consent judgment, I could ask for 30 days for the court to give her time.
All right. The law says you'd have 10, which would take you to September 29th. If we go to 30 days, it would be October 19th. Do you agree to vacate by October 19th?
Yes, sir. Can you hear me?
Yes.
Okay, sorry. I don't have any Wi-Fi today.
I can't see you. All right, it gives you a little additional time, actually 20 extra days. Mr. McCardle, if you would send me a judgment showing that the defendant agrees to vacate by October 19th, 2025, you would have 10 days to appeal this. Do you have any instructions for her what to do with the keys? Just leave them on the kitchen counter?
That would probably be the best thing, Judge. Judge, insofar as getting her signature, would the court be amenable to signing the consent judgment on her behalf with her authority? I know some courts will do that.
I will do that. Ms. Hale, do you agree here on the record that you will vacate by October 19th?
Yes, sir.
And I will note that you acknowledge it on the record. Theoretically, you're to give your forwarding address in writing within 4 days of your moving, but I'm not even sure who you would give it to. I guess the law firm, but you need to leave the keys there. Just leave them on the counter and lock the doors, and they'll come and take possession of the house. If you don't vacate by then, you could be subject to being evicted, and that's not fun for anybody. Do you have any questions?
No, sir.
I have, Judge, just to make sure we're clear, meaning Ms. Hale and I are clear, we are going to enter into consent judgment. She is giving you authority, the court authority, to sign the consent judgment on her behalf. Is that correct?
That's the court's understanding. You agree, Ms. Hale?
Yes, sir.
All right. Our address, it's on the notice. It's 3V Civil at St. Joseph County, mi.gov. And if you would email me that, I will sign it. I'll get it to Ms. Hale. Maybe she and her daughter can jointly find a place to go to within the next 30 days.
Okay, we'll get that to your honor this after sometime today.
All right. Ms. Hale, best of luck to you.
Thanks.
Thank you,
I'm gonna
Judge.
need it.
Thank you, Judge. Have a nice weekend.
All right, we're working on it. Thank you. Good morning, Mr. Kreitz.
Morning, Your Honor.
Mr. Bush is here. He said he was going to finish your cases out, and I guess that's what we're doing. I'll put you in the waiting room until we're ready. I've got a criminal case I'm going to try to cram in here, which is going to cause problems, but we'll do the best we can. So I'll put you in the waiting room and bring you back in a minute.
Okay.
They ready to go?
Prosecuting
turn your box on.
Okay.
Back in here now.
I also have 4 general civil matters at 10. It's always a source of frustration. One of them is settled, so that might help some. Stress is the right word. Meg Bauer is in the waiting room. I've got a young woman who has a fugitive warrant from LaGrange that wants to waive extradition. This guy Collins is going back to LaGrange. Maybe they could take him in the same trip. You haven't been around long enough to maybe remember this. I've mentioned this before. They used to do something called a midnight extradition. Somebody was wanted in Indiana, Sturgis or the county would drive them to the state line and tell them to walk across. And the Indiana guys would be on the other side and they'd pick them up. Do you want to go back to Indiana? Yeah, they drive them there, let them voluntarily walk across the line. I haven't seen one. In fact, I probably don't see them. They don't want me to see them. But when I was prosecutor, we used to occasionally have those. Mr. Kreitz is here with us, Mr. Bush. I've got a criminal case I'm going to try to put in here, but as I knew it would, it's caused a problem. We did do our first matter. We were here yesterday. I didn't figure this out. Tim George and others did. I kept hearing a peep, from a smoke detector, and from over here. And I couldn't figure out what it was. I just learned to live with it. Good morning, sir.
Hey, how you doing, sir?
I'm doing good.
That's good, Mr. Middleton.
Try not to.
Good morning, Josh. Mr. Collins is in our jail. He's wanted in Indiana and he has a very lengthy prison sentence to do. He has 3 retail frauds. I tried to cram it in here this morning when Rhonda was going to be here. She's hard to schedule. And
Yes, she has a lot of vacations to work around.
yes, she's never available on the first Friday of the month for like the next 8 months. But anyway,
Months, Your Honor.
have we worked out an agreement so this gentleman can go back to Indiana?
What?
Have we worked out an agreement so this?
Rhonda doesn't know.
So I just approached him. He wanted me to give a counter. It was denied. So I'm going to tell him the outcome and then I guess we'll see what he wants to do. Okay.
All right, thank you. What have you got this morning?
I was to see you this morning, sir.
On which kind of case?
Oh, we got the Jamie Price.
Oh, okay, you're on that. All right. Yeah, you're in the right
You
place.
know what? They say, no, it's not supposed to be there. What? I said, I want to see you.
All right. Well, you're welcome. You got to take your band off.
Well, Jeff, you already know that it's not a hat. It's I get no waves. I got on it for my wave.
I'm in no position to criticize anybody else's hair. All right. Well, yeah. This guy can't make up his mind. Josh, I appreciate your help on this too. Good morning, Mr. Collins. We met by Zoom. I set this hearing on short notice for today, essentially to allow you to get back to Indiana. Are you Jonathan Earl Collins?
Yes, sir.
Here with your lawyer, Ms. Rhonda Ives. I had some old retail frauds. 242157 SM is a retail fraud, second degree. 251403 is a retail fraud, second degree from June of 2025. And 251647 is a retail fraud, second degree, also from June of 2025. These are all misdemeanors. They're punishable by up to a year in jail and a fine of up to $1,000 or 3 times the value of the property. Oh, there we go. I know you were anxious to just get these matters resolved and get to Indiana and deal with what you need to deal with there. At the time we did this, we didn't have an opportunity to talk to a prosecutor. Chief Assistant Joshua Robert is here. Mr. Robert, is there a plea offer to resolve these 3 cases?
Yes, Ms. Campbell made a plea offer that the defendant could plead guilty in file 243257 SM and 251403 SM. The most recent file, 251647 SM, would be dismissed. There'd be a recommendation for 120 days in jail.
All right, that is a recommendation. My goal was to get you out of our jail. I don't see the point of holding you in our jail for 120 days when you have 60 years or so to do in Indiana, but that's their position.
You know how Indiana though is, it'll be 60 years suspended and they'll be out. No, sir. No, sir.
Well, you never know, but they're very serious charges. He's been convicted and was on abscond status. All right, Mr. Collins, you're going to plead to 2 of these retail frauds and the other one would be dismissed. Do you understand?
Yes, sir.
Other than that, did anyone threaten you to get you to plead to this
No, sir.
or promise you anything?
No.
To understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or a jury.
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. And Ms. Ives has been here. She made a special trip over here this morning for this. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You could also take the witness stand and testify on your own behalf, but you don't have to. And if you did not wish to, the judge or jury could not hold your silence against you. Do you understand?
Yes, sir.
All right, let's talk about the first one. November 10th of 24, Sturgis Walmart. You had a co-defendant, Ms. O'Brien, who she's certainly been struggling too. And
Yeah, she just got 10 years.
she did?
Yeah.
In Indiana?
Yes.
Did she really? She's one of those young girls. I saw her headed toward the waterfall and she just went over the edge. I'm sorry to hear that. And you guys had taken a shopping cart out the side and inside was a air mattress, clothes, a travel mug, and other items, the kind of things that people that are homeless would take, pillows and other property. Did you take that property from Walmart on that day in November? Look at the next one. She got 10 years in LaGrange County. Mr. Robert wasn't exactly completely joking. Indiana does sometimes cut their sentences in half, but that still could be a 5-year prison term.
But sir, I took it to trial.
Oh, you did. She didn't.
Right.
Yeah, you got hard whacked
Yeah.
because you went to
Well,
trial.
they haven't sentenced me quite yet, but my last plea bargain before trial was 15 years.
Well, let's talk about this next one. This was July 3rd at Meyer. An equal opportunity stealer. Myers was you and another guy. This was June 15th. And you filled your backpacks. I guess this had happened more than once. You take a backpack, fill it with stuff, and then walk out with it. The backpack is $45 plus the stuff in it. Gecko Ambition backpack. So did you take a backpack and some other property from the Meyer store? And all right. I certainly understand the prosecutor's request for jail. Try to accommodate both.
I do too, Your Honor, but I'm gonna be in jail anyway.
Yes. I'm gonna order 97 days, credit 7, leaving 90 days to serve. Defendant may be released to LaGrange County and when they're ready for you.
So I can go at any time?
Yes,
Okay.
but if they choose not to, you could do 97 days.
Right. How would I go about that, sir? Just a writ?
Yep,
Okay.
a waiver. All right, that's concurrent with the other case, which is 2-4. Two 157. And in the other one, the 2024 case. I'm gonna order. Seven days, credit 7 days, $125 of costs, or 2 days additional, so you probably won't be going till Monday at the earliest. Concurrent with 2-5. 2157. All right, that takes care of these. You may be released to Indiana. All right, good luck, sir. That is a phenomenon where they were, not just him, stealing the backpack, filling the backpack with stolen merchandise, and then leaving. Anyway, that takes care of all of his cases, so thank you both.
Thank you, Your Honor. Thanks for working this in on a day that I was here.
Okay, thanks. All right, we're gonna switch back to our landlord-tenant docket. I've got Jose Mejia here and Tino somebody. Megan Bauer is here. I've got a phone number here, and Dana Clark is here, and that's gonna take me a minute to identify all these people. Mr. Mejia, can you hear me?
Yeah, yes, I hear you.
All right, could you remove your hat, please?
Yeah, that's one.
Tell you what, why don't you just come right in the courtroom? Just come on in the courtroom. I'll leave that room open, Meg, if we need to do a consult on any of these, but it's gonna take me a minute to identify everybody. We're now 7 minutes behind, but it could be worse. All right, we have a number of cases involving Kreitz Rentals, Inc. Jamie Kreitz, their owner and principal, is present, as is Mr. John Bush, who is attorney for Mr. Kreitz. Also present is Megan Bauer from Legal Aid of Western Michigan. Now, let's see who else we hear. Mr. Clark is here.
Yeah.
I've got Tino U680. Just have a seat, sir.
Okay.
I'm not sure who that is. Tino, who am I speaking with? I've also got a telephone number. Ends in 8945. Who am I speaking with?
Oh, this is Brandon Hargett.
Oops. All right, I don't know who Tino is. They're logged in here twice. This could cause an echo. Can you hear me? I'm speaking with Tino U680AC. Who am I speaking with? Good morning. Can you hear me?
Yes, I can.
All right, I'm gonna mute one of these. What's your name?
My name is John Settler.
You got two things logged in. You got to shut one of them off.
Okay, I'm doing that right now.
All right. All right. Okay. I've got 4 defendants here. Mr. Bush is here, Mr. Clark is here, Megan Bauer is here. So let me advise all of you all at once that you are here on a landlord-tenant matter. These are all primarily failure to pay rent cases. You have the right to hire an attorney. If you cannot afford an attorney, you may see if legal aid can represent you or seek other representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance and be prepared to pay the $50 jury demand fee, or file a written waiver a written demand for a jury within 5 days and be prepared to pay the $50 jury demand fee, unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated entry agency, that's community action agency, Federal Veterans Program or possibly Neighborhoods, Inc. We sent that information to you with the original complaint. You may be able to reach an agreement with a landlord by going through a local community dispute resolution or mediation. If both parties are interested in that, the court can help set it up. Finally, you may be able to reach an agreement with the landlord. That means the case would be dismissed, in which case we would prepare, or Mr. Bush would prepare, what's called a conditional order of dismissal. Somebody has joined us as iPhone. What's your name, sir? Mr. iPhone, what's your name? Your phone is on mute, sir. If you could unmute it, the little microphone icon.
Your Honor, I believe that to be Herardo's family there at 604 Forest. And also Brandon Hargett's case needs to be dismissed. He caught me up and everything is good there.
All right, well, very good. We'll be good. All right, well, let's start with Brandon Hargett. That is file number 251772, Kreitz Rentals versus Brandon Hargett. According to Mr. Kreitz, Mr. Hargett has paid and wishes to dismiss the case. Is that correct?
Yes, Your Honor.
I believe I sent a judgment over. I was hoping that the judgment could just say it was dismissed with prejudice, or I can send over.
I've got one here.
Dismissal. Mr. Hargett's done everything he was supposed to do.
Very good, Mr. Hargett. I'm going to show the case is dismissed.
Awesome.
With prejudice. Defendant paid in full. All right, Mr. Hargett, you're free to go.
All right. Thank you, guys. You have a great day.
All right. Laura, would you come get those criminal cases and give those to Shayna? All right, let's have Mr. Clark. Why don't you come up and have a seat right over here? The next one is file number 251771. People versus Dana Clark. He's got a headband on, but if he takes it off, his hair all pops out. So we'll let it slide. This is filed as a demand for non-payment of rent. Mr. Bush has filed an accounting indicating that through September, rent is $2,244 plus court costs.
Yeah, I don't believe those are the right numbers for Dana Clark.
3,244.
Yes.
What did I say?
Two something.
Oh, okay. 3,244 plus 194 and 376. 3,441.96. Mr. Clark, do you have any kind of plan to get caught up on the rent here?
Well, like you said, Your Honor, I don't think their price is right. Okay, because number one, I know I'm behind on rent. I don't think that price is right. Cause I know I'm like probably 2,000. I don't know where this other 1,000 coming from.
Well, the rent is $116 per week, and he says you haven't paid rent since February of 2025.
February, March, April, May. February, March, April. I think my last was in February, March, April. I know it's in April.
Well, maybe you made a payment in April, but they applied it to the last month that was due.
Yes, sir.
At any rate, you're substantially behind.
Yes, sir. Yeah, I am.
Do you have a plan to get caught up?
Well, like you said, Your Honor, I would like to go through the state of Michigan, like DHS, and see if they can help me pay it. Like you were saying.
Have you asked for anybody?
Well, no, not yet. I haven't, Your Honor.
All right, well, the wolf is at the door. You haven't paid, well, let's even assume you're right. You haven't paid the rent since April.
Yes, that's true.
All right. It's now September, coming into October.
Right. Yes, sir. That's
And
true.
there's
Your Honor.
no likelihood that you're going to be able to continue to pay the rent.
That's true, Your Honor.
So do you have a better plan than that?
That's the only thing I could think of is just go through DHS.
When did you last work someplace?
I got terminated in February. I got terminated. And I was getting unemployment. I was paying money on my unemployment. No, I'm sorry. Yeah, unemployment. And I was paying on that. I didn't pay the whole full amount. That is the truth.
All right, well, you can't expect him to just let you stay there without paying any rent. He has a waiting list of people that want to rent from him.
Yeah, that's true, Your Honor. You're right.
So you're in a tough spot.
Yeah, I am.
Jail on the side, right?
Yeah.
Today is the 19th.
Yes, sir, Your Honor.
Oops. 26. Well, we're gonna repopulate. Next Friday. Well, the law requires that I continue the matter for 7 days.
Yes, sir, Your Honor.
So I'm going to continue this to September 26th.
Yes, sir.
2025 at 10:45. John, we'll be bumping all these to next Friday. Does that work for you?
That works, Your Honor.
All right, Mr. Clark,
Yes,
what
sir.
I suggest you do is you go as soon as you can to DHS or other agency.
Yes, sir.
One issue is you have to pay the entire amount of the arrearage or you're still subject to being evicted.
Yes, sir.
So let's say you owe $5,000 and they give you $3,800, you'd still owe $1,200. You have to pay the whole thing. I don't know that they're going to give you enough money to pay all this.
Right. Yes, sir.
According to him, that rent is unpaid since April or February, you since April. We're going to have to pin the number down.
Right. Yes, sir.
But it's big.
Yes, it is. Yes, sir.
So you may consider seeing if you can find some place to move to.
Yes, sir.
All right, but we will continue this to next Friday at 10:45. You're welcome to come to the court just like you did today.
Yes, sir. Yeah.
You're always friendly. What you need to do is you need to win the lottery again is what you need to do.
Yeah, I know. I hit the lottery before. That's right, Your Honor.
You need to pay. You need to win the lottery to pay your rent these days.
Right. Yeah. This thing's been coming up. You know, when it rains, it pours, Your Honor.
Yes.
I done spent a lot of money on that car. So, but that's no here or there, Your Honor. You know, when it rains, it pours. So.
Yes, it does. And I think it's raining on you right now.
Yeah, you get that right.
We'll address this next Friday at 10:45.
Yes, sir, Your Honor.
All right, you're good to go.
You're a good man.
All right, thank you.
Mr. Milliken.
All right,
At 10:45 next Friday, right?
Yep, right here.
Yes, sir.
Mr. Mejia, would you come forward?
The hiring and release.
Oh, okay. Well, he could use one.
Yeah.
This is entitled Kreitz Rentals versus Jose. How do you say it?
Mejia,
Mejia.
but it's a J, but it sounds like the G.
Yes.
Mejia.
And people's
Yes,
names
sir.
are important and you should try to say them right. And I often don't. At any rate, thank you for your patience. You're here live. I didn't have any issue having you come in the courtroom. If we need to do a consult with Ms. Bauer, we can. Again, Mr. Bush has provided an accounting sheet, says that you owe $3,200 worth of rent plus court costs for a total of $3,442.16. What's your response?
Well, I'd like to know what months I missed because right now I have issues with my wife. We're in a separation.
Okay.
And I just need to know what months I missed because I have to go back to, I've saved all my check stuff, but I have to go back. My online checking account only goes certain far. And I might have to get some bank statements for the months I missed because I did purchase a check from a different bank that I have to go retrieve it, a copy of it. So it seems like
you got sort of the same issue. The rent is paid through February. And what happened, let's say if you made a payment in April, they would apply it to the last month's rent. So you could stop in at Mr. Kreitz's office and he could give you a breakdown. But you also, like Mr. Clark, you acknowledge there's an arrearage, but you don't.
Well, I just need to know what payments I missed so I could check with the bank to see if I did make it or not.
All right.
I just want to be, I want documentation that it's
fair enough.
Because
well, do you have a plan? Do you plan to pay this?
Yeah, I have. I work. I have a job. I'm not lazy or anything. Except for I got laid off. I used to work for Walmart for the maintenance department. I got laid off, and the first 2 months, January and February, I was collecting unemployment. It took a while for me to get the unemployment because they make you wait. So I was short in money. I was applying for jobs, and it took me till February 28th to get hired. Because
where's your new job?
I work for Great Lakes Marine Lamination in Bristol. Yeah.
This one.
You're welcome.
All right, well, we're going to do the same thing. We're going to continue this to next Friday, September 26th at 10:50. Mr. Kreitz, can he stop at the office and go through that accounting?
Yep, absolutely. We can make him copies of it and it'll show exactly the days he paid the money orders and the days that he did not, the months that he did not.
There you go. You know where his office is.
Yeah, I know what I'm saying.
All right, they'll give you that. Then you can see whether maybe one of your checks got misrouted or something. But at any rate, if this is the correct number, you'd get 10 days from next Friday, which would be October 6th, to pay the rent or be subject to being evicted.
Yeah, I'm gonna see if I can get help from the DHS and the other ones.
All right.
And with whatever they don't cover, I will put in. But I think that 10 days is not enough time.
Well, we can continue it, but you guys need to, Mr. Clark didn't do anything. You got the notice to quit some time ago.
Yeah.
So the time to go to DHS.
Understand this when you're going through. I'm going through a hardship right now. I'm going through a separation, and it's really taking a toll.
Yes. In addition to just this, life is going on. People often have medical problems. They have the death of their spouse, which is paying the other half of the rent, or a separation. So people are just trying to make their way in the world. So if you can get some emergency financial help, great. But you need to get on the stick and contact those. If we need to adjourn it because they're going to provide some money, we can do that. But you stop at Mr. Kreitz's office and they'll help you pin down this number. My belief is his number is probably correct, but
I still have to go through my bank statement to see, because he might have, ripped it or thrown it away or something, sometimes people throw copies away.
I understand.
Accidentally,
So I would suggest maybe you stop at his office today get that information, and you need to go to those agencies regarding.
Yeah, I just want to verify that to my bank that I missed them or I paid them. I just want to check my bank to see what happened, why did I miss them, because I'm usually on time.
Mr. Kreitz, when did he make his last payment?
His last payment was August 26th. So he had
All right, so
$1,220 that carried over from 2024. And then he did not pay April or June's rent this year. Or September's. The number is correct.
I'm still.
all right, we'll go up in his office. You can
Yeah.
compare the numbers. I'll see you next Friday, just like this, at 10:50.
Next week at 10:50.
Yes, right here. All right,
So,
Mr.
excuse me, April and June and September of this
He
year.
said you haven't paid April, June, or September, and a carryover of 1,200 from last year.
What months are the ones that are the carryover?
I don't know. We stop and see him.
They'll give you a printout. I think that would be just best.
Yeah, they'll put it written, they'll give you a printout of it.
Because I was consistent, really consistent all 2024 as well. So I just want to know why carryover 1,200.
Judge,
All right, well, I understand. Just go up there and he'll give it to you. And if there's a dispute, we'll sort it out. At any rate, you owe a bunch of money, even if he's right, that it's just April, June, and September. And like I told Mr. Clark, you need to pay the entire amount or you're subject to being evicted. So the worst case scenario is you would have until October 6th to get out or be subject to being evicted.
Okay.
But I would suggest you go up there this morning. He's there, his staff is there, and get that information. Then you can compare it to your bank.
and if it's disputed, he's welcome to contact legal aid to help him figure that out.
Yes, if you disagree with the number and you think he's not correct, a legal aid is available for a consultation.
Oh, legal aid? Okay.
And you got the number, I sent it to you.
Okay.
Meg, why don't you give it to him right now? It's 344-8113.
Yep, area code 269.
Okay. 269.
344.
All right, sir, I gotta go on to my next case.
So what will legal day help me?
Well, if he's incorrect, they aren't gonna give you any money. If you have a defense that, hey, I paid this and he disagrees, I suspect if you can show him that you made a payment and he was wrong, he'll just concede it. But if I had to put money on it, I'd bet on him. It's like, well, I think I paid, I'm not sure, maybe I ripped a check. He's got an accounting and he keeps track each month of all of his properties. So you owe a lot of money and you need to find a way to either pay it or be prepared to move. So the other thing I would do is I would immediately go to those funding resources and see if you can get any emergency help. All right, good luck, sir.
All right, thanks.
Mr. Settler, can you hear me?
Yes, sir. Can you hear me, Your Honor?
Yes. I can't see you, but I can hear you. In this case, Mr. Bush contends, again, a substantial amount of rent. Mr. Kreitz has probably got $30,000 with unpaid rent in just today's cases. Rent money is alleged to be $4,570. Last current as of December 31st of 24. Filing fee and a mailing fee, so the court cost, the total is $4,772.16. Do you have a plan to try to get caught up on this?
Yes, Your Honor. I have a case with DHS. I got to get some documentation to send to them for SER. I'm currently without a vehicle. I'm on a bicycle, so I have to bicycle from Sturgis to Centerville to get this information to the DHS. But I'm currently working on it, and I need a rent printout from Mr. Kreitz to take up to DHS. I've called Neighborhood Inc. and they've told me that they can't help me. So I've tried a couple of organizations and I've gone to DHS. And as I stated, Your Honor, I need something from Mr. Kreitz to take up to DHS to show in my payments through September so they can help me out.
All right, Neighborhood Inc. told you they didn't have any money?
Yes, Your Honor. They called me Wednesday of this week and told me that they don't have any resources to help me at this time.
Judge, I can.
Often their fiscal year is October 1st. Anyway, I'd hope to find out what resources they had. Now, Mr. Kreitz and Mr. Bush, when a defendant has actually made contact with the funding agency, we're supposed to adjourn this 2 weeks. So that would take us to Friday, October 3rd. And John, that would be you're here, I think, for Finrick.
In the early afternoon, then I'm off, going on a short vacation, but if we can walk them right after the.
All right, I'll set it for 1:20 on Friday, October 3rd. All right, we're going to adjourn this 2 weeks, Mr. Settler.
Okay.
And that will take us to Friday, October 3rd. Stop at Mr. Kreitz's office. Now, you got the accounting sheet, which shows how much the numbers are. If you want the exact months, Mr. Kreitz can give you that.
I didn't receive any accounting papers, sir.
All right, well, okay, you can get a copy. I didn't know that I assumed they'd been sent to you.
They were just created late last night.
All right, so we'll get you a copy of that. Anyway, what you want is a month-to-month printout, and Mr. Kreitz can provide that. Now, let me tell you something else.
Your Honor, I have the total amount of 4020.
Yes, that was what was originally filed, but more time has passed.
Okay.
4020 was at the time of the filing.
Okay.
We're now farther down the line. It's another $550 for September. 4020 was through August.
Okay.
4570 is through September. All right, now, the only thing that'll cure this is paying the entire amount. Partial payment will not prevent the writ of eviction. So let's say they give you $3,500. That still leaves you $1,100 short. You have to pay the whole thing to cure it. So let's see what you can do. We'll bump this 2 weeks rather than just one. My advice is you stop at Mr. Kreitz's office and get that printout regarding his calculation for this number. But essentially, you haven't been current through the whole year. And he has a waiting list of people that are waiting to rent. And every month you don't pay, he's just losing out. And this rent is $550, which is about as good as it's going to get.
Well,
all right, I will see you on October 3rd at 1:20.
Okay. And if I may, the Social Security Administration has cut my retirement check down to $580, and I currently was receiving like 1,600 and something, but they cut my retirement check due to some kind of DHS mess up. And I'm in the process of trying to get that taken care of. But right now, I'm only getting $580 from retirement till that money is paid off.
Well, I don't know about that, but,
But that's why I'm having difficulty in paying rent. I got the information right here, but I know that's just water under the bridge at the moment, Your Honor, but I'm trying my best to try to save my home.
I understand, people need a place to live, but he's got all kinds of tenants that aren't paying their rent. He haven't
Right.
paid the rent in 2025. And he's got a list of people waiting to rent this. It's regrettable you don't have any money, but he's got to pay his mortgage. He's got to pay his insurance.
I understand.
So if you can find some assistance, that would be great. But if you can't afford to live there, and frankly, you're not going to find anything at a lower cost than this, unless it's subsidized. And if you get evicted from this, it might make it difficult or impossible for you to get into subsidized housing.
Yeah,
So the first thing I would suggest is you go to Mr. Kreitz's office and get the printout, take it to DHS. But you're going to need some money because you have to pay the entire amount. To further complicate things, we'll be in another month. We'll be in October, and another $550 will be due for the month of October.
Exactly.
All right, I'll see you in 2 weeks, October 3rd at 1:20, okay?
All right, thank you, Your Honor.
All right, good luck with all that. Mr. Kreitz will provide that information if you ask for it.
Okay, thank you, Your Honor.
All right, we've got some other people that have joined us. I'll remove Mr. Settler.
Are we finished, sir?
Yes, we are. You're good to go. He's also Tino. All right, Herardo joined us. We've got Herardo Rangel. We got Michael Hegman and Valerie Hegman. We got Damon Savage. And we've got Randy Shrader. So let's take a minute, advise all of you of your rights as a tenant in a landlord-tenant proceeding. These are all non-payment of rent cases. Your landlord has asked you to pay the rent in a residential property or move. It's called a non-payment of rent case. In such a case, you have a right to hire an attorney. If you can't afford an attorney, a legal aid may be available to assist you. Our representative from legal aid is here. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must advise me at this hearing or file the written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay. As you heard in some of the previous cases, if your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated agency, that's Community Action Agency, Housing Assessment and Resource Agency, that's Neighborhoods, Inc. Apparently they don't have any money, or a Federal Help for Homeless Veterans Program.
You can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer. That time would run consecutive to any additional prison time that you get sentenced to. Officer, would you check with the jail and recalculate or calculate the jail time credit, or Mr. View, and then whatever the jail time credit that the jail says that you were in our jail, you'll get that credit.
Okay, I have a printout of it from the records officer.
Okay, but again, I don't know. I don't keep those records. I rely upon other people checking those records, and they tell me what the jail time credit is. But whatever the credit is, I'll give you credit. Right now, she's saying it's 36 days.
Yes, there were times that after we had released him, he was still in our custody on holders for other counties, so we were waiting for them to be picked.
Okay, so you understand you don't get credit for that time if you're in our jail on holders from other counties if this court's released you. All right? Any question? All right, sir. Good luck to you.
We sent that information to you with the original summons mailing. You do not need a judgment against you to get assistance from the places listed above. Copy of the summons and complaint for your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, we can help set that up. You may be able to reach an agreement with the landlord. It means the case would get dismissed, in which case we would prepare what's called a conditional order of dismissal and proceed based on that. Mr. Bush could help assist in that. All right, Mr. Rangel, can you hear me?
Yes, we can.
All right. This is Herardo Rangel and any occupants at 604 Forest Street. As in the others, this is a demand for non-payment of rent. And rent is alleged to be $8,400 plus court costs of $8,602. Rent last paid fully last August. This one's really old. Again, Mr. Rangel, what's your position?
Our position right now that, well, right now, me, Herardo Rangel, I'm speaking. I'm his son right now. He can't really speak English real well, so I'm his translator for now. Okay. And right now, he had an accident at his work and that caused him not to work anymore. But we reached out to Neighborhood Inc. that was willing to help us pay the full cost of partial cost, of the rent, and we plan to pay the rest of the rent in whatever money we could get. But we were just looking at the numbers of how much rent it was, and we have receipts and everything. We make sure to save them, and we kind of try to do the math ourselves, and it was half of it. And I'm not sure.
Well, we have to sort that out. I would recommend that you go up to Mr. Kreitz's office and he'll give you the breakdown. But according to him, now, no rent has been paid since last August. I don't think that's correct. I think it's just everything that you pay, they apply to the last month. But it's way behind, according to him. Mr. Kreitz, when was rent last paid?
So rent was last paid in August, and most of this is from last year that they owed a $7,000 carryover. I carried them for quite a while last year and was supposed to get it taken care of. Tax time came and went. He does try to pay, $100 or a couple hundred more every month, but it's just not cutting it anymore.
All right, I would make the same recommendation. You go up to his office and ask for his breakdown. Legal aid is available if we need to fight about that. You have also asked for assistance, so I'm also going to adjourn this to August 3rd. I'm going to jam up that afternoon at 1:25.
I think you mean October 3rd, yeah?
October 3rd, yes. I've been doing that a lot this summer. Now, as I told the others, the only thing that'll cure this is paying the entire amount of the rent. When you go up there to Mr. Kreitz, he can give you that accounting, which you can share with Neighborhoods Inc. The only thing that will cure it is paying the entire amount. I think what I will do is get an interpreter here for the next hearing.
Yes, please.
Your Honor, they did, I believe it was Neighborhood Inc. sent over a bunch of forms. We filled it out. We sent it, we emailed it back to them. We told them when they received it, please verify that they did receive it, and we did not hear back from them. I don't know if it went to their junk mail, but I think they are trying.
All right, very good. He can also agree to work with you if you can get a substantial payment. He doesn't have to evict you on that 10th day, and we'll talk more about that next time. But I will see you on October 3rd at 1:25. Okay?
Again?
October 3rd at 1:25. You'll get a new notice. It'll be the same Zoom number as this, and I will get an interpreter.
Okay. And then I wanted to real quick, so with Neighborhood Inc., could I still go to his office and ask for details about the breakdown and stuff?
Yes, I'd ask you to do that even today.
Okay.
All right, very good. I'll see you in 2 weeks.
All right, thank you so much. And are we good to leave?
We're good. Yes.
All right, thank you so much.
Thank you.
All right, maybe we can get where we need to go on that one. Next is Michael Hegman and Valerie Hegman. File number is 251776. This one is set for 9/20. We're substantially behind here, but we're doing the best we can. This is Larry Kreitz versus Michael Hegman and Valerie Hegman. Can you hear me?
Yes.
All right, this is the biggest one of the day. This is a weekly renter of $130 per week, and it's substantially in arrears. He alleges that your current arrearage is $12,832 plus court costs for a total of $13,073 and 66 cents. What's your position, Mr. and Mrs. Hegman?
Basically, I've rented from Larry since 2007, and I started with, well, anyways, I've been behind basically since 2007, and unfortunately through hospitalizations and car problems, everything else, I've just gotten, we've gotten in arrears more and more and more. So, you know, his total's probably pretty accurate, actually.
Have you asked for any emergency help?
We have in the past, and at that point in time, we were denied because I made too much money.
Have you made any provision to try to move?
Yes.
We are in that process right now.
All right. I'm going to continue this to next Friday, September 26th. That's 10:50. Let's just say 11 o'clock. Now, let me tell you a couple things. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your move. After he moves, he can assess the property and he can apply your security deposit to any unpaid rent or other costs. He can also file an action for the unpaid rent. This would just have to do with possession. Next Friday, September 26th, I'm going to tell you that you have until October 6th to move or be subject to being evicted. So essentially, you've got 10 days plus 7 to find another place to go or be subject to being evicted, unless he agrees to give you more time. So we're going to revisit this next Friday right here at the courthouse, if you wish, at 11 o'clock. Do you have any questions?
No.
Do you know where you plan to move?
Tennessee, actually.
All right. All right. Okay. I'll see you next Friday, all right?
Okay. Thank you, Judge.
Tennessee. I heard you made fun of me when you heard I moved to Tennessee. People are struggling. Mr. Kreitz, these are substantial amounts of arrearage. I'm not even sure how you can continue to operate with these much of a shortfalls.
These were actually his father.
What?
These were his
Oh,
father.
these are Larry's, okay. Next is Larry Kreitz versus Damon Savage. Mr. Savage, can you hear me? Can you hear me? All right. Mr. Bush, again, has provided an accounting breakdown, and this makes my life so much easier and faster. Mr. Savage, is Kate Bowman there with you also?
She's actually watching our newborn.
Okay. Let me make my notes here.
It's my ex-landlord.
This is entitled Larry Kreitz versus Damon Savage and Kate Bowman. Whoever's here on the phone number, I'll get to you in a minute, but you can't just speak. You're in the middle of a court hearing, so stay with me, and when we finish these, I'll identify who you are and see who we're talking with, but you need to be quiet. All right, another great big fat arrearage, $9,672 plus costs of $9,915.26. Mr. Savage, what's your position here?
I've actually been trying to get help from Neighborhood Inc. I'm just trying to figure out a way to pay the 6 months. I went in there for an interview with Mary, and she said that she's able to help. I just got to figure out the way to pay the 6 months, the back pay up to 6 months.
Yes. You have to pay the entire amount or you're subject to being evicted.
Yeah.
So Neighborhood Inc. apparently has some, I really wish I would have been able to meet with them to find out what the deal is and what their fund, but I tell you this, there is insufficient funding no matter what for the amount of need we have. People all over the county are struggling to pay their rent. Landlords are trying to keep their creditors at bay. What's happening is the small landlords like Mr. Kreitz are disappearing. And they're getting purchased by large companies who charge a lot more in rent. But the small landlords like the Kreitzes and the Richmonds and the others are becoming smaller and smaller in number. And big corporations don't have the same level of compassion and they cost more money. If this was a big corporation, you'd already be gone. You'd have been gone a long time ago.
Yes.
But the downside is we got a big fat arrearage. All right, in order to do this, you have to pay the entire amount as indicated. If they give you an award, you have to pay the rest of it, but you've asked for assistance. We're going to continue this to October 3rd. Mr. Bush wants to get out of town, but we're going to have to continue this to 1:45. This is your dad's case. Do you know if Larry got the packet from Neighborhoods, Inc.?
I did not receive it. He would have brought it over to me, so I'm gonna say no.
All right, well, you need
I
to,
have a computer, so I doubt it.
okay.
They have not lived in that house for several months.
Mr. Savage is not there anymore?
No. The house has been empty. Their stuff is still there. He's paid a total of $800 this entire year of 2025. Water and lights got shut off, and we switched them back into our name so we would have no issues with the city. But the place is sitting empty.
All right, well, Mr. Savage, this sounds like you just needs to move.
We
Yes.
planned on moving. Our storage unit got locked, so we've been trying to figure that out, why it's still locked, because we did a small little payment on it, and they're like, yeah, we'll unlock it so we can get our stuff out. It's just they haven't unlocked it yet.
Well, Neighborhood Inc. isn't gonna give you a bunch of money for an apartment that you're not living in. You need to get your stuff and plan to get out. Because you have contacted Neighborhood Inc., I've adjourned this 2 weeks rather than 1, which is gonna raise because we're gonna be into the month of October. And my suggestion is you prepare to move by October 13th.
All right.
All right, we'll address this further. What you got is a very expensive storage unit. And Mr. Kreitz is getting deeper and deeper in the hole each month. Plus, he's paying your water and utilities. Plus, he's got people ready and willing to rent this house. So my suggestion is you just try to get your stuff out as soon as you can and turn in the keys to Mr. Kreitz and your forwarding address in writing within 4 days of your moving.
Alrighty.
All right, I'll see you in 2 weeks, 1:45 on October 3rd.
All right.
All right, let's keep plugging away here. I also have some 10 o'clock general civil matters, which we are behind considerably here. This next matter is Larry Kreitz versus Randy Shrader. Mr. Shrader is here also. I'll remove Mr. Savage. I've got other people coming in. But let's talk about this. Good morning, Mr. Savage. Can you hear me?
Sorry,
Or
Judge.
Mr. Shrader, excuse me. Mr.
Yes, good
Shrader.
morning. Good morning, Judge.
This is Lawrence Whittleson. Hello?
All right. Yes, I can hear, I can see you.
Judge, can you hear me? This is Mr. Shrader.
Yes,
Good morning.
good morning.
Good morning. This is Lawrence Whittleson.
All right, I'll be with you in a bit, sir.
Okay.
Stick with us. I'll identify you and we'll take up your matter here in a minute. All right, this is also a non-payment of rent, also substantial. Larry Kreitz versus Randy Shrader. File number 251778 LT. The arrearage is $5,079 plus cost $5,729.06. Mr. Shrader, what's your position here?
Well, my arrearage come from 2019 and early 2020. I went through some hernia surgeries and they failed. So I had to apply for Social Security. And then I had a lawsuit for a hernia mesh claim. And I've been waiting for that attorney for 7 years now. And I've come to the point to where I financially I could probably pay an extra $200 a month. I know it would take a couple years to pay off, but I'm willing to, I'm willing to pay that. I was just waiting for an attorney, and both me and Larry both have been waiting for the settlement, and it doesn't seem to be coming anytime soon. So financially, like I said, I could probably pay an extra $200 a month.
Well, he can agree to that. He doesn't have to. Mr. Kreitz, is that true? This arrearage has been carried on for years?
It has been quite a while. I think, we were waiting on his settlement, but in this business, we hear that a lot. I'm not saying it's not true. I have no idea, but, father's waited a long time. He's 82 now.
He's been paying his rent since then, but this is an arrearage?
Correct. We do have other people living in the place. When I was there for an inspection, there looks like there's quite a few people staying there as well. I don't know if it was just temporary at the time or not, but
they're not on the lease?
Not that I believe.
All right, so there's that factor as well, Mr. Shrader. You got off-book people staying in there.
No, they're no longer here. My daughter's got her own place.
All right. Well, he can agree to some sort of repayment agreement like this, but he doesn't have to. Megan, I'm interested in whether there's some sort of latches agreement or something that they just let this go for 6 or 7 years, and whether he's forfeited his right to attempt to collect it.
Yeah, I was thinking the same thing, Judge. There's not a bright line rule on that, but there's a couple of questions here, like the renewal kind of pointing towards a waiver, even though it's renewed each month, the acceptance of the rent subsequently. But obviously don't want a bright line rule that makes it impossible for tenants to enter repayment plans and have landlords waive those either. So truthfully, Judge, I would have to look at it more closely. Off the top of my head, latches has been in the back of my mind all morning. Yeah, but that's
well, all right. You can talk to Larry about some sort of plan to reconfigure this. Latches is a legal theory, Mr. Clark or Mr. Kreitz, that has to do with essentially letting a debt or claim get stale in layman's terms, and at some point you lose the ability to perfect your claim because you've delayed so long. It's not exactly like statute of limitations, but it's similar. And it could be a statute of limitations, but 7 years to wait for a settlement, I mean, makes me ashamed of the legal system. All right, we're gonna continue this to next Friday, September 26th, 2025 at 11:15. Mr. Bush is here with me anyway. And we'll explore that further. In the meantime, you can talk to Mr. Kreitz about some sort of repayment agreement, and he could do a conditional order of dismissal. But he's not losing money like he is with some of the other ones where the people just aren't paying at all. You're paying now.
Yes, I haven't missed a monthly payment since early 2020.
Interesting. All right. I'm not sure he can do this, but we'll see. All right, if we need to address it further, we could adjourn it and you could consult with legal aid again at that time, but we're going to continue this to next Friday at 11:15.
I do show, Your Honor, 2 months in 2022, no rent was received. June and July.
Well, that's only slightly better. It's 3 years ago. All right.
Randy, I'll talk to my father and we'll get with you, okay?
Thank you very much.
All right, thank you. Otherwise, he sounds like a good tenant. All right, for those that are here on civil matters,
Thank you, Judge.
Your Honor.
Yes. You're free to go, Mr. Shrader.
Thank you so much. Have a great day.
I'll remove you. Thank you. All right. Now I've got a number of other people who are here who I need to identify. Melissa's here. It's been except for 9:45. And someone is here with a telephone number. We've got Cooper v. Rice, and that's set for 9:40, and I don't see either party. I thought Mr. Rice was going to be here. I've got Sweet Lake versus Bennett, and Ms. Hull is here, and Ms. Wing is here, and Ms. Bennett is not.
Lawrence Whittleton is also here.
All right, Mr. Whittleton, you're a civil case, and I'll get to you in a minute. But let me give you I got, Mr. Whittleton, your number ends in 76.
Yeah.
All right, give me a minute. When you're here by telephone only, it ain't great.
Well, I have a reason for that, Your Honor.
All right, we'll get to you in a minute, sir. Just stay with me.
Okay.
I've got another phone number, 9050. Who am I speaking with? I've also got Samsung. Your microphone is muted. Who am I speaking with? I think that might be Miss Cooper. Are you Diane Cooper? I can try. Good morning. Are you Diane Cooper?
Yes.
All right, let me give you a name. All right. And I'm still trying to figure out who the other person is. 8950. Someone's here by telephone. I don't know who I'm speaking with.
Judge, 8950 is Attorney Jeremy Chisholm. I'm just, the computer just.
All right.
I'm sorry about that. I had to log in by the phone because my computer was updating, and so I logged in my phone, and then as soon as the update finished, I logged in on the video here. So I have now hung up the phone call there, Judge.
All right, very good. Ms. Osterman is also here on Discover Bank. We're going to finish our land. We got a little behind with some clunkers, and we're doing the best we can. But let's take up Sweet Lake versus Bennett, file number 251799LT. Meg Bauer is here. Meg, I don't know if you
Ms. Bennett did call my office after the first hearing. We are down one key support staff person. So an intake hasn't been completed with her. We have, as far as I know, we haven't heard from her again, but like I said, we're short of staff, so I don't know that they've been able to get through all of our calls this week.
All right, well, this is a clunker.
I'm not gonna do this right now.
Ms. Cooper,
Yes.
I'd ask you to just be quiet. Mute your microphone, but hopefully you can unmute it when we get to your case in a minute, but just remain quiet. Meg, I just sent you an email. They filed some photographs. This is one of the worst cases of hoarding I've seen. These pictures are shocking.
And Judge, Attorney Hall did actually communicate with me throughout the week. I appreciate that. So I think I did look at them last night. I thought that they had made a potentially reasonable proposal, but she's not here. I don't have authority to enter anything on her behalf.
Good morning, Mr. Stickley.
I was just seeing if you had time today.
2 o'clock. I thought they sent an email out.
It might have, I was just on a meeting.
Everybody else is gone but me, and I've got a really dense civil morning. So 2 p.m., that'll give you enough time to take your time at the fair, so you don't have to rush.
Oh, yeah, I won't be there.
I did that just for you.
Thanks.
All right. Recall, this was the case that was sort of half fish and half fowl. It was a lot only, and then it was a hazardous, and it's her trailer. And I get, anyway, Ms. Hall, you were trying to sort this out too. Well, what's the status?
Well, Your Honor, we filed an amended complaint because we filed the wrong type of 7-day complaint. We filed a non-payment of rent case. So we filed an amended one for health hazard. And I know Ms. Bennett's been talking to the property manager. She was trying to get a couple weeks to vacate. The issue is, I mean, it's a health hazard, I think, for Ms. Bennett herself, but it's also affecting neighboring units or homes. They have had to deal with a lot of pest issues that are coming from this unit with rodents and insects and stuff like that. So I think it's in everybody's best interest if she vacate, or I think her plan, as far as I know, is to turn the title over to the property.
Can you tell us into your car and then I'm done? Are you in any pain?
Ms. Wing, would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Would you state your name?
Melissa Wing?
And you're the manager at Sweet Lake,
Correct.
and you've managed other parks in the past.
Yes.
Did you take the pictures that were forwarded to the court?
I did not take them. Her family member, her brother, actually, took them and sent them to me. They actually came to me asking for help for her. That's why I started the process. I didn't realize the inside of the home was as bad as it was. They had been telling me that, but.
Have you been in the home?
No. She opens the back door and talks to me, and the smell is horrendous.
Well, she is not here.
She was aware. I spoke to her yesterday. She doesn't want that eviction on her record. And,
Well, this is removing the trailer. So if she agrees, Ms. Hall, I don't think I have a judgment.
No, I have one. We didn't send one to well, I don't know. I wouldn't have done it. I don't
I'm
know.
going to grant judgment as hazardous property. Defendant has, in the just cause termination, it would be 90 days to move or sell the home and 10 days to move. This is just filed as a hazardous damage complaint. And as you know, judges all over the state are struggling with these non-just cause terminations. But I believe this is lot only, is that correct?
Yes, she owns the home and is just renting the lot.
Defendant has 10 days to remove the mobile home. Or vacate and relinquish premises. Ms. Hall, I'd ask if you'd send me a default judgment. 10 days from today would be the 29th of September.
Okay, I can do that.
It's also the appeal date. Ms. Bauer's hands are tied. She doesn't actually represent the defendant. She is aware of the circumstance. She is not here. And if these pictures are to be believed, Ms. Wing can't verify them. She was provided by them. It's a hazardous to her. It's one of the worst I've seen. And she has 10 days to vacate. She knows this hearing was today. We talked about it last week. She talked to the manager. She'd been in contact with legal aid. The best thing she could do is get out of there, relinquish the trailer. The park may want to remove it or try to rectify it with some significant cleanup. All right, Ms. Hall, she isn't here. She knows what the deal is. People can't live like this in this day and age. She has 10 days to remove the trailer.
Thank you, Judge.
I'll send that over or file it.
All right.
Thank you.
Our next matter is Diane Cooper versus Larry Rice. I had fully expected Mr. Rice to be here this morning. He's been in here several times this week. Any sign of Mr. Larry Rice? All right, he's a friend of Paul's. All right, thank you. Bye. All right, Miss Cooper, can you hear me?
Can you hear him?
Yes.
Can you hear him?
Mr. Cooper, is Mr. Rice there with you?
No.
I'm Mrs. Cooper.
All right, and you have this property on US 12?
Yes.
And Larry Rice is living there and you want him to move?
Yes.
Yes.
Does he have a lease?
No.
This matter was set for 9:40 this morning. It's now 10:20. He was in here several times this week, I think including yesterday. He's quite agitated, but he isn't here now. I've got David Argenti and Mr. Littleton's here. I have him and he isn't here. Is he still there?
Yes.
I dealt with him in an earlier case, a foreclosure. And I believe he suffers from significant mental health problems. Is he still exhibiting that?
Yes.
Is this the same house or an apartment in your house?
Apartment.
And you don't have a lease?
No.
I suggest you get one if you're going to rent this again. Well, he isn't here. So I expected him to be here. He wanted to be live in the courtroom, but he isn't here. So he has 10 days to move, which is September 29th. No money judgment is entered at this time.
See, okay.
Okay.
If he does not move, you have to bring $15 to the courthouse and the sheriff will do an eviction.
Okay.
They have done, he's been evicted before. It was very difficult for the sheriff, but they did finally get him out. He painted my name all over his house and was very unhappy. I don't know that he has anywhere to go, but he isn't here. He clearly knows to be here. I'm not sure what happened, but he isn't. So he has 10 days to move or he's subject to being evicted.
Okay.
10 days
All right.
from today.
10 days from today, the 29th of September. On the following day, September 30th, you can come in and ask for a writ of eviction.
Okay.
All right, thank you. All right, we're 25 minutes behind, and we're going to address our civil matters, which are set for 10. And we have Orbit Leasing and LaShonda Jones, and Mr. Jeremy Chisholm is here on behalf of Orbit Leasing. The defendant is not, so that won't take very long. So I'll set that one aside. Lawrence Whittleson is also Orbit Leasing, and he is present. Discover Bank is Jordan Osterman. Also present is David Argenti. We'll deal with that. And we have Barclays Bank versus Michelle Sims. Nobody is here on that case. I received a stipulated order for conditional dismissal. So we have 3 matters, 2 Orbit Leasing and 1 from the bank. Let me take these files out. We'll do the Discover Bank first, and then Mr. Chisholm, do you think there's any benefit for you and Mr. Whittleson talking in the breakout room? You're on mute.
Sorry about that, Your Honor. Yeah, I'm happy to try.
All right. Well, Mr. Whittleson, I'm going to put you in a breakout room where you can talk with Mr. Chisholm, and I'll bring you back in a minute. Okay. But I will still be here. So when it should put you in there automatically.
Okay.
All right. Ms. Osterman, give me just a moment. I'm going to take all these files out. I'll be right back. entered in this. And I didn't have time to eat it. But let's stop the record, restart it. Every landlord-tenant day, in the middle of it, I have several general civil cases, which sometimes can be problematic, but we'll do the best we can. All right, so this matter is entitled Discover Bank versus David Argenti. Attorney Jordan Osterman is here on behalf of the plaintiff. Good morning, welcome to Centerville.
Good morning, thank you.
Mr. Argenti, can you hear me?
Yes, I can, Your Honor.
Can you turn your camera on?
Unfortunately, I am at work right now, and the device that I'm calling off of does not have a camera.
All right. This is defendant's motion to set aside a default. I didn't call the case. It's file number 25750GC. He filed a formal motion to set aside the default. The default entered in this case, Judge Pattison signed it for me while I was on vacation on July 24th in the amount of $5,101.76. The defendant was served with this lawsuit on May 18th of 2025. More than 21 days passed, in fact, more than 60 days passed, and the default judgment entered on July 24th. I was sitting on a porch on Mackinac Island on that day, and the defendant then filed a motion to set aside the default, and that motion was filed on August 15th, which is 21 days after the default entered, if my math is correct. Discover One Bank has filed a response. In order to set a default judgment aside, well, they allege two things: that did not file it within 21 days after entry of the judgment. The judgment was July 24th. If we put 6 days in July, he filed his motion on August 15th, which is 21 days. The bigger question is, he has to show just cause for failing to answer the complaint and a meritorious defense. He filed something which is a little hard to discern. Mr. Argenti, you filed a motion to stay garnishment. There is no garnishment, although there could be. And you filed this motion to set aside a default. Under the court rule, you're supposed to show good causes why you didn't answer the complaint and the fact that you may have a meritorious defense. More than 2 months passed before the default entered. And then on the last day, you asked to set the default aside. What's your just cause for failing to appear?
So I had actually called on June 10th at 11 in the morning to settle with the plaintiff. And we had came to an arrangement, and they failed to send me the paperwork for it. But yeah, I tried to settle with them outside of court, so that way it didn't come to any default judgment or anything, and I just never received the paperwork for it.
Ms. Osterman, do you have any knowledge of that?
I do, Your Honor. So we did speak on 6/10. The defendant agreed to sign a consent judgment and to agree to a payment plan of $125 a month, beginning on 7/18. I do see that. I'm not sure that that paperwork went out to the defendant, so he is correct on that. We did not receive a payment on 7/18 regardless, and we did not hear back from the defendant. I know that his motion to set aside was really more concerned with the garnishment. we have stopped processing that garnishment. So that's not moving forward. And we're happy to enter back into a payment plan with Mr. Argenti, considering I don't know that he got our paperwork and he never ended up making that first payment, but we're happy to move forward with it and continue on with a payment plan. The plan was always to have a judgment in place, and I don't believe that Mr. Argenti is denying the debt is his. So if Mr. Argenti is agreeable, we would just go ahead and move forward with that payment agreement.
All right, Mr. Argenti, would you agree to pay this debt at the amount of $125 per month?
I would definitely love to settle. At the time, I was really just trying to do my best to keep it out of the courts. At that time, when I had settled for, excuse me, $125 a month, my fiance was working at the time, and unfortunately, she has been laid off since then. So right now, my finances are not the same as they were when I made that settlement. So if there's any way that I could get that lowered, that would be great, as $125 a month would cause me to struggle a decent bit.
Mr. Argenti, what do you think you could afford monthly at this time?
I think I would be comfortable if I could do somewhere around the $50 range. That's just what I can do right now. I make $17 an hour at about $40 a week. And right now, all of my monthly finances are about $2,100 for all of my bills and everything like that, not including the 2 children I have to feed and do diapers and everything for. So right now it's already paycheck to paycheck. So just doing $125 monthly would probably set me over the edge at this point.
So at a garnishment.
Yes. Yes, Your Honor.
They always envisioned that a judgment would enter. If they're willing to accept 50, that's all right with me. If they're not, then we'll see where we go. Ms. Osterman, do you have the authority to accept that?
I may. Do you know, can we discuss how much are you making, Mr. Argenti, per paycheck?
So my hours do vary typically.
Let me see if I can put you in a breakout, disclose all this financial stuff on the live feed. And we'll then defer to Mr. Chisholm. And let me get Mr. Chisholm out of here. Oops. All right. Mr. Osterman, Ms. Osterman, you join the breakout room, and Mr. Argenti, we'll put you in there too.
Okay, thank you.
And then you can discuss those.
Thank you, Your Honor.
issues. I'll work on my next case.
Okay.
Thank you.
All right. Good morning, Mr. Chisholm. Thank you for your patience.
No problem at all, Your Honor. Good morning.
You have had an opportunity to talk to Mr. Widowson. I have his name spelled wrong on there. Let me call the case. This is file number 221712GC. It's Mr. Widowson's motion to set aside an it's your motion to set aside an installment payment. This one isn't huge. Defendant had stopped making his payments and was $1,200 in arrears. I've been setting these for hearing because I set it aside, then the defendant asked for another payment agreement. We end up chasing our tails. So I try to get everybody in the same place at the same time, see if we can come to some solution. You had an opportunity to talk with Mr. Widowson. What's the status here?
So, Judge, unfortunately, no payments have been received on this since back in, it's been over a year now. Still a $3,000 balance remaining on the case. It doesn't sound like Mr. Widowson's in a position to make the payments that the installment payment order requires. So at this point, I've got to ask the court to set it aside.
Mr. Widowson, what's your position?
Right now, I am in rehab. I just had a stroke on the 1st. I don't know when I'm going to get back to working. I asked if there's any way that we can just take the the payments out of taxes. Like when I get my taxes, you guys just take it out of the taxes.
Yeah, he can do that if I set this aside.
Okay. Well, because I just recently had my mother die, and I'm in a money jam right now, and I don't know when I'm going to be able to actually get money and pay, and I don't want to keep going back and forth with this. And I'm trying to be honest, and that's the only thing that I can.
I appreciate your candor. People are struggling. Every week I have people like you that are just you had health problems, you lost your mother, you don't have any money. But if I set this installment order aside, they can garnish your state income tax.
Well, okay. Well, I can understand that. I'd rather them take what, I'd rather them take what they can take at the end of the year rather than us keep going through this every single year. At least we know that, hey, this is going to be taken out this year. This is going to be taken out this year. So, by, well, how much do I owe?
$5,523.64 was the original judgment. The amount now is maybe something less than that.
$3,030.64.
303064.
I'm not sure if I don't know when I'm going to be back on my feet to actually do that.
They can't garnish your wages if you don't have any. And they basically, you're uncollectible right now, but they will be able to seize your income tax. So I'm granting the order to set aside installment payments. Are you still at 13th Street, lot 53?
Yes, I am.
All right. Where were you working?
I was working for the state of Michigan, home health. I was a home health care worker.
Now it sounds like you could use some home health care. All right, Mr. Whittleson, I've granted their order to set aside the installment payments. You can't make any payment. You don't presently have the ability to pay, but this will give them the authority to garnish your tax refund. All right, best of luck to you, sir.
All right, thank you very much.
Our other Orbit leasing matter is.
I got a question, sir.
Yes.
When I do get on my feet, can I still make payments?
Yes, certainly. Once you get back up and operating, you contact Mr. Chisholm's office and perhaps they can set up a repayment agreement at that time. But it sounds like it's going to be a while before you get back on all four tires. All right, good luck to you, sir.
All right, thank you.
All right, we also had Orbit Leasing versus LaShonda Jones. This is filed 2041GC. This is defendant's motion for installment payments, I think.
Well, it's a moot point at this point now, Your Honor. Satisfaction judgment has been filed. She paid off the account.
Oh, very good. I
think your court should have this satisfaction. I think it was filed on Tuesday or Wednesday of this week. So we're good to go on that one.
All right. Well, it hasn't made it to the file yet, but I appreciate that. And this matter will be closed. Satisfaction of judgment has been filed. Those are the best kind.
That's the best possible solution, outcome. I'm always happy to be able to wrap one up like that.
Very good. I'll see you next time.
Sounds good, Judge.
And
Thank you.
hopefully I won't make the wait so long, but I promise I won't. But all right, I'll see you again. Thank you.
Have a great weekend, Your Honor. Take care.
Okay. All right, let's return to Discover Bank versus David Argenti. The parties were put in a breakout room. The original agreement was 125. Plaintiff was willing to reinstate it. This is a return to file 25750 GC. Ms. Osterman, what's the status here?
We were able to agree to a payment plan of $100 a month, and we will do a review of that payment plan in 6 months. And I will be sending those documents over to Mr. Argenti by email.
All right, I'm going to deny the motion to set aside the default as there is no good cause shown and there is no meritorious defense. But I will place under other, defendant shall enter into a repayment agreement at $100 per month starting. When are we going to start this?
I allowed us to push it out to November, so he's going to start on November 18th, Your Honor.
Subject to review in 6 months. All right, Mr. Argenti, are you still at Erie Street, lot 72?
Yes, Your Honor.
All right, you're going to repay this at $100 per month starting November 18th, subject to review in 6 months. I guess it could be amended up or down depending on your circumstances at that time. The judgment stands. There isn't a good cause and meritorious defense were not established. So defendant shall enter into a repayment agreement at $100 per month starting November 18th, 2025, subject to review in 6 months. Is that acceptable to you, sir?
Yes, Your Honor.
All right, Ms. Osterman, I believe this is the first time we've met. If we have met, I apologize, but sorry about the delay. We're 45 minutes behind, which could be worse.
Yes, no problem.
All right, well, I'll probably see you again. Thank you for your help in resolving this matter. Mr. Argenti, good luck to you.
Thank you, Your Honor. I hope you can get
Your
your
Honor.
pumpkin donut soon.
It might be noon before I get it.
It might be.
All right, thank you.
Yep. Have a good one. Thank you.
Okay. It's an Entenmann's. All right, we're about to then shift back to our landlord-tenant docket. Good morning, Mr. Bradshaw.
Morning, Your Honor.
This is set for 10:30. We're 14 minutes behind, but we'll do the best we can. This is Vista Point Apartments versus Grant Canals. Mr. Canals is here in the conference room. Manager, Mr. Davidson, is here. John Bradshaw is here. He was here last time. We continued this matter till this morning. Defendant has an arrearage. He was going to try to work on getting this matter resolved. The parties were put in a breakout room and we weren't able to get to the finish line. Mr. Bradshaw, what's the status here today?
So just a quick recap, excuse me, just a quick recap of where we were last week. Our original prayer for relief for the month of September was $1,389. That included 600 because of 6 times 100 late payments. I cut those in half and took off $300. So that leaves a current amount due through the month of September of $1,089 and $200.50 in court costs for a total of $1,289.50. I had a conversation with Mr. Canals in the last since the last hearing, and he told me that he could pay 1/2 of that in October and 1/2 of that in November. We came up with a date of paying that 1/2 in October of 10/4 and the other half on 11/4. Those amounts are $644.75. In addition, he stated he could also pay the rent on October 4th and November 4th. So I have prepared a conditional dismissal, just the form 508, that provides the case is dismissed today upon the following conditions: that he will pay the total amount due of $1,289.50 as follows, which is under paragraph. Defendant shall pay $644.75 on 10/4 and 11/4/2025, in addition to the respective rents due on those months, period. Default on any of the above payments is a default of this order. I believe Mr. Canals is in agreement with that, and if he lets me sign his name, I will submit that to the court.
Yes.
You agree with those terms and conditions?
That was 644 what?
75.
Yeah. And I'll send you a copy too, Mr. Canals.
Okay.
Well, if you send it to me right now, Mr. Bradshaw, I'll sign it and give a copy to Mr. Canals before he leaves.
Okay. Can I just write under the defendant's signature, agreed on the record?
Yes. So, Mr. Canals, this is going to be dismissed, but if you don't comply with the terms, it could be instantly resurrected and you could be subject to being evicted.
Yes, I understand that, Your Honor.
All right, Mr. Davidson, your manager, is here, and I suggest you stay in contact with him. You're going to pay half October 4th, half November 4th, plus you're going to pay October's rent and November's rent.
Yes.
So that should get you squared away, and this case will show us a dismissal. Mr. Bradshaw's going to email it to me, and I will sign it and give you a copy before you leave.
Okay.
My advice is always stay in contact with your manager, let him know what your circumstances are. So, Mr. Canals, if you go out to the counter, the ladies will bring me the order, I'll sign it, and you can go to the fair.
Okay.
All right, thank you. Do you have any questions?
I don't.
All right. Mr. Bradshaw, we learned that Casey Strong had never been to the fair, and we were very disappointed in that. I don't think we got her there yet. So
no, and she's working, but she's not feeling well, so I don't know if she'll make it this weekend.
No, I don't think she's going to. So I'll give her the same hard time again next year. So see how we do. All right, Mr. Canals, you go out to the counter. We'll get you a copy of that order, Mr. Bradshaw. Thank you.
Thank you. Thank you, Paul.
Thank you. All right, Mr.
Thank
Simpson, thank you. They stole Casey Strong from the prosecutor's office, which was a good get for them. But she is still doing some criminal defense work. All right, I'm going to stop the record. We have a supplemental complaint for money damages set at 11. And Meg, I don't think you're on that one, but this case, well, wait a minute, we have two. We have Sturgis Housing Limited, which is a supplemental complaint. And then we have that Golden Pond Estates, which I was hopeful would settle.
Beal Properties versus Jasmine Loza.
Not checked in.
Jasmine Loza, they are not checked in. You may proceed.
Thank you, Your Honor. Based on my client's books and records with respect to Ms. Loza, there's currently rent to retain of $2,047.30, cost of $175 for a grand total of $2,222.30. Plaintiff moves for the entry of a default judgment for possession only with an order of eviction to issue after September 29th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Beal Properties versus Jasmine Brown.
Daniel Landman on behalf of the plaintiff, Your Honor. I believe Ms. Brown is present.
Yes, and also
I'm here.
Deontay McDaniel. Yes, ma'am. All right.
Good morning.
What? Good morning. What is plaintiff's claim in this case?
Your Honor, plaintiff's claiming rent to retain of $843.68 and costs of $214 for a grand total of $1,057.68.
And ma'am, how are you intending on getting this paid?
I'm working with
I need a camera, ma'am, if you do, if you can.
Hold on. Let me see. Okay. Can you see me?
Okay, there you are.
Okay.
Yes, ma'am.
So yeah, I'm working with SOS. I had called Hawk and they put me through the SOS. So my caseworker that I was working with, she got sick. So it should be paid by next week, basically.
Okay. By next week, will you pay it before what time?
12 noon.
Can you get that paid before noon on next Friday?
Yes.
You think you can? All right.
Yeah, I think because I already went
Okay.
through everything. She just was sick, so it was Elizabeth Fink is who I'm working with.
Okay, very good. So what I will do is I'll adjourn this out to 26.
Yep.
To September 26, 2025 at noon.
Okay.
Okay, if that's paid and you make sure that it's paid, you won't need to appear. Otherwise, that is an in-person hearing.
Okay.
So you'll have to come down to the courthouse if it's not paid.
Okay.
Okay?
All right. Thank you. Have a good one.
All right, you too. Beal Properties versus Teresa, is it Egems? And also Terry Egems.
Daniel Landman from appearing for the plaintiff, Your Honor. At least one of the tenants is present.
There's only one tenant. It's Teresa Igems, and Terry is my nickname.
Okay, very good. All right. So you're Teresa.
Correct. And
All
Terry.
right. And Terry. Okay. So, well, my issue is that I have two defendants.
Right.
I'm not sure why that.
Now, I'm trying to figure that out as well, Your Honor. I'm checking the lease.
They just have both names.
Okay. And your preference on which name is?
Terry.
Terry? Okay. I will try to remember that for the next time. So, all right. All right. What is plaintiff's claim in this case?
Your Honor, plaintiff is claiming rent to retain of $1,926 and costs of $214 for a grand total of $2,140. In a chat prior to your taking the bench, I believe this tenant indicated that she was seeking state emergency relief.
That's correct.
All right. So you are doing an SER?
Yes, and I also have an appointment with SOS on Tuesday, this upcoming Tuesday.
This upcoming Tuesday, the 22nd, 23rd?
I believe so, yes.
All right. So two things. How many people are in your unit?
Just one.
Just one? Okay, so just so that you know, and that if an SER is granted, that's only going to net you about $410. And the other amounts would have to be paid prior to them paying that, so that you're aware of that. Okay?
All right.
All right. The other thing is, in your packet that you received from the court, there is what is called a rental assistance form. You'll need to fill that out, put your SER tracking number on there, and supply that to the court by next Wednesday.
Okay.
All right. And I will adjourn this out to September 26, 2025 at 12 noon. That's an in-person hearing, ma'am. Is there any payments that you can make between now and then?
Not at this time, no.
No? Okay. All right, very good. Then we'll see you then, and then we should hopefully have some news regarding everything else. All right?
Okay, thank you.
Thank you. And Beal Properties versus Justina Youngblood and Nevaeh Griffin.
Daniel Landman appearing for the plaintiff.
No one has checked in. Griffin, Youngblood, you may proceed, sir.
Thank you, Your Honor. Based on my client's books and records, the current rent to retain is $1,478. There's also costs of $214 for a grand total of $1,692. Plaintiff requested a possession judgment enter with a writ date of September 29th.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ issue in 10 days.
Thank you, Your Honor. That covers our cases. Have a great weekend.
You do the same, sir. Evergreen Apartments versus Carnell Harbin.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Good morning.
I have not checked it.
They are not checked in. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is an action for non-payment of rent. The rent to retain possession is $3,012.39. Court costs of $172 for a total redemption of $3,184.39. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with a writ to issue in 10 days. Evergreen Apartments versus Markayla Jennings.
Parissa Gazari for plaintiff.
Ms. Jennings?
Hello?
Hello. Good
Can you
morning.
see me?
Yes, ma'am, we can.
Okay.
All right. And what is plaintiff's claim in this case?
Your Honor, the outstanding balance is $3,039.09, which includes court costs.
3,039 and how many cents? I'm sorry.
9.
9 cents. Thank you. All right. And Ms. Jennings, how are you intending on getting that paid?
I know I'm gonna pay $850 today.
Okay. You're going to pay $850 today? Okay.
I only get paid every 2 weeks.
Okay. And this is your pay week? All right. Okay. Have you tried to work out something with the landlord or seek assistance?
No, because Sydney typically doesn't give any like plans or anything.
I'm sorry?
I told her I should have it all paid up by mid-October, but she just said go to court, so.
All right. So your part of your plan is that you get it everything paid, including your October rent paid by mid-October?
No, it's October included by the end of October.
I'm sorry?
My old balance by mid-October, but October by the end of October.
Got it. I see what you're saying. Because you need that next paycheck to try to clear that, right? Okay. So I'd suggest that you talk or call the attorney's office, see if something can be worked out. If it can't, what I'm going to do is I'm going to adjourn this to next week. That'll be September 26, 2025 at 3 p.m. That's an in-person hearing, so you'll need to appear at the courthouse, okay?
Okay.
Okay, get the $850 paid to them, however. All right?
Okay.
Okay, thank you.
Thank you. Bye-bye.
Evergreen Apartments versus Carlos Warden.
Carissa Gazeri for plaintiff.
They are not checked in. You may proceed.
Thank you. The rent to retain possession is $1,700.16. Court costs of $172 for a total redemption of $1,872.16. Plaintiff is requesting entry of a default judgment for possession. The writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with a writ issued in 10 days. Evergreen Apartments versus Kayla Smith.
Carissa Gazeri for plaintiff.
I think she is, there she is.
Present.
Hello, Ms. Smith.
Hello.
All right. And what is plaintiff's claim in this case?
The outstanding balance is $2,592.37, which includes court costs.
All right. And Ms. Smith, how are you intending on trying to get that paid?
I paid $1,400 yesterday.
Okay, you paid $1,400 yesterday?
Yes.
All right, Ms. Gazeri, does your ledger reflect that?
No. No.
Does not? Okay. And so you're gonna have a balance of about 1,200 left. And how are you gonna try to get that done?
I'll make another payment of like $500 next week.
So
And then-
500 by what date?
Thursday, which I believe is the 25th.
25th, all right. Okay, and then what's your plan for, that's gonna put you down around 900, so what's your plan for trying to, or about 1,100, I'm sorry. No, 12,700, sorry, my math is bad this morning. All right.
It's about 12 right now. So
Right.
it should take me down to around 6 after I make that payment.
Yeah, your math is as bad as mine. Actually, it takes around 7. All right, okay.
Well-
So,
Well, I'll probably pay it's like $11.92. So I'll probably pay
Right.
like the 92.
got it. Okay. But you're gonna
I'm
need.
working on it.
You're working on that. Okay,
Yeah.
let's do this. You paid the 14, you're gonna pay 500. We'll leave it there for right now. I'll adjourn this matter out to September 26, 2025 at 3 p.m. Okay, that's an in-person hearing. So if it's not all paid up, you'll need to come down to the courthouse and let's see what we can work out, okay?
Okay.
All right, thank you. And we'll
Have a
both
good
work
day.
on our math in the meantime, okay?
All right.
All right, you have a good weekend.
You too.
Evergreen Apartments versus Ruth Palmore and Denisha Moore.
Carissa Gazeri for plaintiff.
All right. And I think Ms. Palmore is here. Hello.
Hello.
All right. What is plaintiff's claim in this case?
The outstanding balance is $2,307.96.
All right. And ma'am, how are you intending on getting that paid?
I get paid next Friday, and my plans was to pay that next Friday.
Next Friday?
Yes, next Friday.
Okay, so the entire balance by the 26th?
26.
Okay, can you get that
Yes.
paid, say before noon on that date?
Yes, sir.
Oh, you can? Okay.
Yes,
If you get
sir.
that paid
I'm sorry,
before
my phone.
noon-
I'm at work. I'm sorry.
No, I got you. It's okay. And that way they can check it. So I will adjourn this out to September 26, 2025 at 3 p.m. If you get everything paid, you don't need to appear. Okay, but you got to make sure you have everything paid. If you don't have everything paid, then you'll need to appear at the courthouse for that hearing. Okay? I think she froze on me.
Okay.
All
I'm sorry.
right.
Yeah,
Very
it's
good.
freezing up.
No, it's okay.
Thank you.
It's okay. All right. Thank you. Get back to work.
Thank you. I will do.
All right. Take care.
You as well.
Gulfside Lake 3. Is that That's okay. That's not how they're labeled. Gulfside Lake 3 versus Jonathan Henderson.
Carissa Gazeri for plaintiff.
Jonathan Henderson.
Yes.
Okay, there you are. Okay, good morning.
Morning.
Okay, what is plaintiff's claim in this case?
Your Honor, the outstanding balance is $3,077.31, which includes court costs.
All right. And sir, how were you intending on getting that paid?
Right now I certified for, I put in an SCR request also, and I certified employment. I haven't been paid out unemployment yet, and that's something I'm working through. So I will know something from that by next week. But I will be able to pay something on the amount next week also. I'm not sure how much it will be, but it will be at least $1,500.
You think you can pay $1,500?
Possibly.
That's an estimate, but sometime next week.
Yes.
Can you do that before next Friday? Or is that going to be?
I'm hoping to do it by the 23rd, but Friday is very possible.
By that Friday?
Friday by noon, yes.
Okay, so you think you can pay it by the 26th at noon? Okay, so I'll put that down in there. With reference to your SCR, how many people are in your house?
Just one.
All right. So if that's granted to you and they do that, you'll need to know that that only will account for about $410.
Mm-hmm.
Okay, so they aren't covering a large portion of it, and they would require that you pay everything else before they're going to pay. You follow me?
Just pay it as such.
Okay. So the other thing is that in your packet, you'll see what's called a rental assistance form.
Mm-hmm.
That rental assistance form needs to be filled out. The tracking number for your SCR needs to be put on that form, and that needs to be submitted to the court by next Wednesday.
Okay.
Okay.
So
I'll adjourn it. Go ahead.
I'm sorry to interrupt. I'm listening.
No, go ahead.
Oh, so I have to bring that into court, or I mail that in?
Yes, that has to be in the court by Wednesday with your tracking number on it. Okay? All right. So I'll adjourn this matter to September 26, 2025 at 3 p.m. If everything is not paid, sir, that's an in-person hearing. You'll need to be down at the courthouse, okay?
Yes, sir.
All right. Thank you. Court does call the case of Gulfside Lake versus Samantha Gonzalez.
Carissa Gazeri for plaintiff.
Samantha Gonzalez, not here. You may proceed.
Thank you. The rent to retain possession is $149.49, court costs of $172, for a total redemption of $321.49. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
All right. Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with the writ to issue in 10 days, no writ without a hearing.
Thank you.
All right. Gulfside Lake versus Natasha Olmos.
Carissa Gazeri for plaintiff.
Olmos.
Hi, I'm here. How are you?
I'm good. You were on camera. There you are. Okay.
Hi.
All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $2,125.57, which includes court costs.
And ma'am, how are you intending on getting that paid?
I have an SCR application in. I actually just got out of inpatient rehab that you sentenced me to. I have my certificate right here.
Congratulations. Fantastic.
Thank you. I'm happy to be home. So I've been gone for almost 6 weeks now. So I haven't been able to work, but I do have pending child support that was paused while I was in there because their dad had them. And then I also have pending unemployment benefits. So I plan on, I've already put the SER application in. I'm communicating with some other agencies as well. And I plan to get that paid as soon as possible, as soon as they approve my application, but it's pending right now.
All right. So how many people are in your house when your children are with you? So
5.
I'm 5. Okay, so the
Yep,
maximum
5,
amount.
including myself.
Okay, the maximum amount an SER will pay will be $870. Okay.
Okay.
All
All right. And
the
I'm working
other
with other
thing-
agencies too as well.
All right, Ms. Olmos, just listen to me for a minute, okay? Let's see if we can get some assistance because you're trying to get yourself back on your feet and straighten things out outside of yourself, right? Right now.
Yes.
Okay, so first thing is, because you filed an SER, there's a rental assistance form in your packet. You'll need to fill that out, put the tracking number of your SER on that, and get that to the court by Wednesday.
Okay.
Okay?
Now, can I email that or do, bring it in?
Yeah, you can email it. You can email it to the court. Okay?
Okay.
And then the other thing that I want you to do is we have a court liaison officer and there's a program, I think that is called Rising Hope. And so I want to try to tie you into that. If you qualify for it, I can't be sure, but it's to assist with housing in some way. I'm not entirely clear on everything for those that have been impacted by the criminal justice system. Okay.
Oh, awesome.
All right, but I don't know if that's just Section 8 certificates or exactly what it is. So I'm not clear, but we might as well give it a shot, okay?
Okay, what's it called again?
The program is called Rising Hope, and I'm gonna let you talk with Amy, and there may be other resources out there. She's our court liaison officer, so she may be able to get you in touch with things, all right?
Awesome. Awesome. Thank you.
You're doing well, though.
Very well. I'm happy to be home.
Okay, all right. I will adjourn this out to September 26, 2025 at 3 p.m. That is an in-person hearing, so you'll need to come down to the courthouse if everything is not paid, okay? And then
Okay,
we'll see
sounds
where
good.
we go. We'll see where we go from there, okay?
All right. Thank you.
All right, hold the line one moment. Amy, I know you were there.
Good morning, Your Honor. I am.
All right, fantastic. We're going to put you in, I think you were probably listening. We're going to put you into a breakout room with Miss Olmos. She's a good person. She's been doing the work. So we had our run-in with each other, but I think she's good. Okay.
I'll be happy to speak with her. Thank you.
All right, we'll put you into a breakout room. We'll see you next week, Miss Olmos.
Perfect. Thank you.
Pardon? Okay. Gulfside Lakes versus Lucia Williams.
Carissa Gazari for plaintiff. I think there's one other defendant as well.
There is. And Karan Williams. They are not present. You may proceed.
Thank you, Your Honor. The rent to retain possession is $1,884.56, court costs of $214 for a total redemption of $2,098.56. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested, writ to issue in 10 days. Hamilton Crossing versus Desiree Trim.
Carissa Gazari for plaintiff.
They are not present. You may proceed.
Your Honor, this is an action for termination of tenancy. Defendant's tenancy was terminated pursuant to a 1-month notice to quit. Defendant has failed to appear. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession. There is no redemption amount. Writ to issue in 10 days.
Thank you.
All right, thank you. And then I just have Glencoe versus Little, Glencoe Hills versus Little. That is dismissed. on plaintiff's motion without prejudice.
Thank you.
That's all I have for you.
Thank you.
All right, take care. That's it for that block. All right, 14A stands in recess.
The judge is going to talk to you one-on-one.
Good morning. The docket will begin momentarily with the playing of the advice.
All right, very good. All right, so you're gonna put it in the Dropbox?
Can I say something really, really quick? Totally respectful. The only thing I have against the drop-off box is I've put my rent in a drop-off box. It was a couple years ago, but I put my rent in a drop-off box and it disappeared. And it was a whole big case about I let PK Housing know. I let them know, hey, look, I paid it. I put it in there. I even took a picture of it, and then it went missing. And then they tried to take me to court for it, knowing that it went missing. And it was a whole big thing. I had to call the MoneyGram back, get them to void it, to send it back. So I just try to hand it to them in person. That way I know that it's turned in. Is it okay with you? Can I turn it in Monday morning first thing? Or do you want me to put it in the drop-off box? Because I just get scared to put it in there. I don't want it to go missing because it's a lot of money.
Somebody will be there Monday morning?
Correct. I believe that's what Anton indicated.
Yep,
I'll be there at 10 o'clock.
Ma'am, get it paid Monday.
Yes, sir. I have it
All
right
right.
here. I have it in full, and I promise.
I will adjourn this matter out to September 26, 2025 at 1 p.m. That's an in-person hearing, but if you've got everything paid, just make sure to double check with them that they've got it. If you've got everything paid, you do not need to appear.
Okay. Yes, sir. Thank you so much. I promise I will have it first thing in Monday morning.
All right, fantastic. Thank you.
All right. Thank you so much, sir.
Thank you. Maple Heights Apartments versus Nicolette Burnham.
Alex Tolzman on behalf of the plaintiff. This one will be a dismissal, Your Honor.
It is. Okay, this case is dismissed. That's without prejudice. Plaintiff's request.
Thank you, Your Honor.
Ready? That's it. You do the same. Pine to Clover Lane versus Evan DeCossin.
Good morning, Your Honor. Brent Tinger for the plaintiff, P80491.
He's here. We're prompting him.
There he is.
Yeah.
Mr. DeCossin? You'll need to unmute, sir.
Can you hear me now?
Yes, we can hear you now. Okay, very good.
Lovely.
All right, what is plaintiff's claim in this case? Right now, there is rent owing of $28.43.48. There's court cost of $175, leaving the balance as of today at $3,018.48.
Sir, how are you intending on getting that paid?
I'm literally just waiting on a paycheck, a check away from that. I had some automotive issues that put me a little bit behind.
All right. So you're gonna get this paid in full when you get that paycheck, or what are we talking?
Yeah. It'll be about a week or two, and then I should have everything.
Okay. When is you're waiting to get paid? Is that the issue?
I'm waiting on my next check, sir.
Okay. When is your next check?
It will be, hang on. It would be the 29th, but likely I can get that sooner.
All right. Here's what I'm going to do. I'm going to adjourn this to September 26, 2025 at 12 noon. Okay.
Can you say that again?
Next Friday, the 26th at 12 noon. That is an in-person hearing, so you'll have to appear at the courthouse unless everything is paid.
Okay.
All right?
Yes, sir.
Thank you.
Thank you, Judge.
Thank you, sir. Six Trails versus Cheyenne Nash.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Good morning, Cheyenne Nash.
Oh, thank you. This is a termination of tenancy.
Correct, Your Honor.
And it's for unauthorized occupants. Ma'am, what's your position on this?
So my brother lives there. He is on the lease as an occupant there. So I recently got married and I moved to Westland, and I didn't think it would be an issue for my brother to live in the apartment since he's already on the lease for it. So I don't understand like what the big issue is.
More than just her brother. That's part of the problem, that there's multiple people living there.
Your judge, I brought my mom with me. It's Joni Simpson. She's not on the docket. I called Six Trails and I recorded a phone call. I forgot the lady's name. It starts with an L. And she was trying to state that my mom lives there. My mom does not live there, and that's why I brought her to court today. And what the original thing was with Six Trails is if I wanted to like sublease and get it fully out of my name, my mom would have to like co-sign with my brother. So I wouldn't have any responsibility. And that's something that we discussed before in the past. But I did bring my mom, and my brother is on the lease. And I do have a recording with Six Trails trying to state that my mom.
What about Evan Marshall? What about Evan Marshall?
Evan Marshall. So this young boy, he has schizophrenia and he has bipolar disorder, and he would get into an argument with his mother. So my brother was like, come over here, chill out with me, so on and so forth. And then he would go back to his mom. Him and his mom even did a tour with Six Trails to get him his own apartment at Six Trails. They decided that it was too much, and now he lives at Red Roof Inn. So I don't see the issue with a friend coming over to get away from.
Okay. Hold on. Here's what I'm going to do.
Mm-hmm.
I'm going to adjourn this for an in-person hearing, and I will set it for September 26, 2025 at 1 p.m.
Mm-hmm.
All right. And that'd be an in-person hearing. So everybody needs to be here. Now, Mr. Katz, are there 3 people that you've?
Well, that's what I'm trying to find out. So if Miss Nash can actually call me, can I give her my number, and maybe we can talk about this and see if we can get this matter resolved so we know exactly what's going on over there.
Miss Nash, what do you want to say?
I do want to say, so rent was not paid. They cut off my internet web portal access in order to pay rent. We had an emergency down in Kentucky from a family member, and we sent a personal check that they also denied. So they're cutting off my way to pay rent on top of it.
No, they're obligated to not accept payment from you once they file a termination case.
Even through web?
The law does not allow them to accept payments from you.
Even through the web portal? So that's the reason.
Portal.
Right. So, ma'am, what you can do is one of 2 things. When you come down next Friday, you can bring that amount of rent in cash and you can pay it to court escrow. Okay. Mm-hmm. That's one of the ways that you can do that, so that this case can proceed and we can try to get it resolved. All right.
Okay.
And can I give Ms. Nash my number? You can give me a call later today. Ms. Nash, you want to write this down, Ms. Nash?
Yep.
248-761-0215. Okay?
Okay.
Thank you.
All right. Thank you.
Thank you, Your
Thank you
Honor.
so much, Judge Simpson.
Thank you. Take care.
Take care.
Is that a female? Bushwood Properties versus Anthony, is it Spatafor?
Good morning, Your Honor. David Fanter on behalf of plaintiff.
Spatafor, they are not checked in. If you want to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
I'm David Fanter. I'm the attorney for plaintiff in this matter, and as such, I'm familiar with the books and records as they relate to this tenancy. In this case, there's rent owing in the amount of $2,608, court costs of $175 for a total of $2,783. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount, and the amount requested, writ issue in 10 days. Bushwood Properties versus Crystal Duff.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
And Justin Nicholson. I think Ms. Duff is here.
Hello.
All right.
Yes.
Hello. All right. What is plaintiff's claim?
Your Honor, the total balance owing at this time is rent of $1,225, court costs of $188 for a total of $1,413. I actually had a conversation with Ms. Duff yesterday, if I could tell the court.
Yes, go ahead.
So she made a significant payment this week, which basically cut her balance in half. And she said she's going to pay the remaining balance next Friday. So rather than her trying to get it in before we have to come back, I agreed with the court's permission to adjourn 2 weeks.
Well, I don't have the 3rd. My next date would be the 10th. Do I have the 10th? Pardon?
I'm fine with the 10th. I trust Ms. Duff.
Okay.
Everything she said she was going to.
All right, ma'am, I'll adjourn your case to October 10th, 2025 at 1 p.m. That's an in-person hearing. If you get everything paid, you won't need to be here, but they'll dismiss it if it's paid before the end of the month. But otherwise, then you'll need to get it paid or be here, I'm sorry.
Yes, sir.
Okay?
Okay. Thank you very much.
Thank you. Mrs. Haverkamp, LLC versus Christopher Decker.
Good morning, Your Honor. David Fanter on behalf of plaintiff.
Not checked in.
They are not checked in. You may proceed.
The amount of rent that's owed is $2,845. Court costs of $175 for a total of $3,020. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested with the writ issue in 10 days. Mrs. Haverkamp versus Taylor Elam.
Good morning, Your Honor. David Fanter on behalf of plaintiff.
Ms. Elam? Need to unmute.
Good morning.
Good morning. Okay, what is plaintiff's claim in this case?
In this case, there's rent owing in the amount of $2,125, court costs of $175 for a total amount owing of $2,300.
All right. Ma'am, how are you intending on getting that paid?
Well, I start both of my new jobs here in 2 days. I start training for 1 in 2 days, and then hopefully the next follows.
Okay. Have you talked with your landlord at all about trying to resolve it?
No, sir. I just recently got my phone back and back on. I've been trying to email. And
okay. Have you reached out for any other type of assistance, ma'am?
No, sir.
All right. I suggest that you may want to do that. I'd also suggest maybe you contact Mr. Fantera, the number, that's the attorney for the plaintiff, see if you can work something out on this. That number will be on your paperwork that you received for this hearing.
Yes, sir.
Okay. I will adjourn this matter out to September 26, 2025 at at 12 noon. All right, that's an in-person hearing, so you'll need to be down here at the courthouse, okay?
Yes, sir.
All right, thank you.
Thank you. Have a good day.
Here. Court calls the case of Red Line Apartments versus Amanda Nestriak and Michael Nestriak.
Good morning, Your Honor. David Fanter on behalf of plaintiff.
All right. Ma'am? Good morning.
Good morning.
All right. All right. What is plaintiff's claim?
The amount of rent that's owed is $2,560. Court cost of $186 for a total of $2,746.
$2,746. All right. Ma'am,
Yes. So
how are you guys going to get this paid?
So I had to move out for my son and my safety because my brother is going through a really bad addiction and he ended up becoming physical. And he's hiatus right now. I haven't heard anything from him. So I don't know what the next steps in ours is. And I had to move to Dearborn Heights with my mom. So I just
Okay, so you're not, hold on. So Michael is your brother?
Yes.
Okay. And so you're not in the unit, right?
No, I moved out. I have a few things and I was gonna clean up after him and stuff because it was pretty bad. He keeps going in and out of the hospital and I don't understand, and it's just a lot of things, and for my safety, I had to leave.
All right. And let me ask you this, is it your intent to not go back?
Yes, I did talk to Rachel, my landlord. I told her I wanted to try to get rest of my stuff sometime this weekend and hopefully have like an officer come with me, and just in case if he is there.
You try to do. Gotcha.
Yeah.
Okay, so here's what I'm going to do, ma'am. I'm going to adjourn this to September 26, 2025 at, what is it, noon? 12 noon. That's an in-person hearing. However, what I'm also going to suggest in the interim, you've talked to your landlord, but I'd also suggest that you contact Mr. Fantera and see what can be worked out regarding this unit. Okay?
Awesome. Thank you.
All right. Thank you. Walkabout Creek versus Beth Sherfield.
Good morning, Your Honor. David Fanter on behalf of plaintiff. I think there's a second defendant there also, Your Honor.
Yes, there is, and Barbara Sherfield. Neither are here. You may proceed.
The amount of rent that's owed is $3,338. Court costs of $181 for a total of $3,519. We'd ask for a judgment for possession with a writ for 10 days if that amount remains unpaid.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with writ issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fanter on behalf of plaintiff.
Bertram.
With the court clerk, duties of the court clerk, they shall endorse on every pleading and all other papers filed in a proceeding how the date and hour of the filing. And it goes on to say recycle paper. It also provides service pro se inmate, which would determine you filing thing. That is the extent of that order. There is nothing in that order, in that rule, that requires the state to file a written response to your motion to suppress. Therefore, your motion, your judicial notice / notice of objection to the state's failure to file a written response to the motion to suppress is respectfully overruled, and we are ready to proceed. State may call your next witness.
Excuse me, Your Honor. Can I make an objection to that? It doesn't state the request that the DA file a written response, but it does require that the state give notice and of anything that she files under. I've not received a notice of who her witnesses was, or I haven't even been.
There's no requirement, Mr. Vaughn, of that. There's nothing in the rule that you filed under that requires the state to give you notice of the witnesses they're going to call, nor does it require them to give you notice of any writing that they have. And to my knowledge, the state has not filed any written response. Is that correct, General Brosky?
That's correct, Your Honor. What about notices for court dates? I've twice in this court, I've been called to court without even giving a notice.
There is no validity upon your objection to based on those things, and your motion has been denied, so we're moving forward. All right, General, call your first witness.
State calls Corporal Lindsay Javins.
Corporal, if you'll come forward, please.
Still ain't got all my questions. I can start.
Corporal, if you'll slide the base of that, there you go. Thank you, Officer Moyer.
I just ain't got much.
Are you Corporal Lindsay Javins?
Yes, ma'am.
Would you spell your first and last name for our court reporter?
First name Lindsey. Last name Javins, Jav as in Victor, INS.
And Corporal Javins, were you, how are you employed?
I'm a corporal with the City of Dixon Police Department.
How long have you been in law enforcement?
I have been in law enforcement since 2017.
Was all of that with the City of Dixon, or have you worked anywhere else?
Prior to that, I worked for Fairview Police Department.
On June 18th of 2022, were you working with the Dixon Police Department?
Yes, ma'am.
And that night, did you come into contact with the defendant, Sharik Vaughn?
Yes, ma'am.
And what was the reason for coming into contact with him?
Originally, we had a call for a possible domestic at Walmart. The vehicle description was given that he was making threats to kill the female and the children.
And did you make contact with him at Walmart or somewhere else?
I observed them pulling, they had just pulled onto Beasley Drive. I observed the vehicle, same tag, all of that, and I made a traffic stop at Dollar General on Beasley Drive.
So you initiated your blue lights, it's a full-on traffic stop?
Yes, ma'am.
When you approached the vehicle, who was driving?
Mr. Vaughn.
And how did your conversation with Mr. Vaughn go?
Well, I asked Mr. Vaughn to step out of the vehicle due to it being a possible domestic. I wanted to separate the parties to look into what was going on. He refused to do so. I asked him approximately 8 times to step out of the vehicle, and he refused to do so, even after being told of his obligation to do so. I had to open the door and assist him out of the vehicle.
Ultimately, did you place him under arrest?
Yes, ma'am. So also during that time, during the investigation on scene, it was determined that his license was revoked as well.
So you initially arrested him for resisting?
Resisting and driving unrevoked.
And the state's not moving forward on the resisting charge, but he's still being prosecuted for driving unrevoked?
Yes, ma'am.
Did you confirm that he was revoked? Did you learn that by speaking to him, or was it something that you ran a system?
It was through dispatch.
Once you got to the jail, let me back up. He has been charged with retaliation for past action. When was the first concerning statement that the defendant made?
As we were entering the jail.
What did he say as you were entering the jail?
As we were entering the jail, he told me that he was a threat for a reason.
And did you clarify that?
I did. I tried to clarify. I asked him again. He said, I'm a threat for a reason.
And were there any further statements that were concerning to you?
Yes, ma'am. So I'd obtained my warrants by meeting with the magistrate before I went to the jail. Got to the jail to serve those warrants, and so he could be booked. I was up doing my paperwork. I'd finished completely, and the jail staff still had him in handcuffs. I told them that I needed my handcuffs so I could go. There was some hesitation with the jail staff to remove the handcuffs, and they went around to try to remove them. At the beginning, I was assisting, and then he became upset because I was assisting because I was touching him. So as soon as more people got over there, I stepped back so that I was no longer touching him. During that time, they were trying to get the handcuffs off, and not a direct quote. We may have to do the video for the direct quote, but he was saying that whenever I got hit in the jaw, that it was going to be their fault because they wouldn't let him go because they were trying to take the cuffs off. Then the female jailer was telling him, like, please stop tensing up so we can get the handcuffs off. And he said, believe the direct quote was, "Fuck no, I'm going to beat that bitch up."
Taken all together, did you take those statements to be in reference to you?
Yes, ma'am.
And then before the charge was taken out, of course, you heard the testimony of Stewart last week.
Yes, ma'am.
Did those add to your perception that these remarks would have directed at you and law enforcement?
Yes, ma'am. So after the incident, we spoke, and he encouraged me to document because I explained to him what he was said to me as well. He encouraged me to document that in my report just in case something did occur in the future. And he did happen to, try to assault me, harm me, kill me, as he implied. So that was documented in my report. And then whenever it went to grand jury, that's whenever that charge was added.
Nothing further at this time, Judge.
Mr. Vaughn, you have the right to question this witness. If you wish to question the witness, you'll need to come to the podium, please. And I would remind you that this is not an opportunity for you to make statements. It is an opportunity for you to make a question.
Yes, Your Honor. Your Honor, will my elbow counsel be allowed to make some follow-up questions after I'm done?
He is your elbow counsel. He cannot ask questions, but he can assist you in asking the question. You've elected to represent yourself, so his role is to give you advice in counsel, not to actually actively participate in the trial. Unless you want him to. If you want him to, then I'll allow it. You want him to assist you?
Yes, to assist me, yes, as elbow counsel, yes. You allow that?
You may.
All right, thank you. Can you say your name for me, please?
Lindsay Javins.
You go Javins, Ms. Javins?
Javins, yes, sir.
I believe what will you tell the courts what you did? What did you arrest me for again? What was the reason for your arrest?
Driving on revoked and resisting.
Driving on revoked and resisting. Okay. Driving on revoked was the charge that you gave me. No, excuse me. Let me rephrase that question. Resisting arrest was the original reason you arrested me, correct?
I arrested you for driving on revoked and resisting.
So when you pulled me out the car, you were planning to arrest me for driving on revoked and resisting, correct?
You were removed from the vehicle, and yes, you were going to go for resisting, yes, sir, but you were also revoked. Whenever I went to the magistrate to present my affidavit to them, that was for driving on revoked and for resisting arrest.
Okay. Okay, so the original charge was resisting, correct?
The two charges together, that was what was presented to the magistrate.
Do you believe that your arrest was justified?
Yes, sir.
You believe that you did that to your best of your abilities?
Yes, sir.
You don't believe there was no illegal intent or malicious intent involved in it?
No, sir.
Do you believe that I truly resisted arrest?
The fact that I asked you 8 times to get out of the vehicle and you failed to do so to the point where I had to open the door to get you out, yes.
So did I use any force, resistance, threat of flight, or harm to you?
You remained in the vehicle and did not get out.
So that's a no?
I did not have to fight you, no. After the door was opened and you got out with me.
Okay. What was the reason for you wanting me to exit the vehicle?
I was investigating a domestic because I had a call for service stating that you had made threats to kill the female and the children. So I made contact with you. For a domestic, we want to separate the parties to be able to hear both sides. You were asked to step out of the vehicle and didn't do so.
Is that the only chosen method that you could use, or was that just the one you chose to have me to separate us?
That was the method that I was going to choose, yes,
That
to
you
separate
chose.
you. That is what we do in domestics.
Okay, is there any other methods that you can use, or is that the only one?
If you'll clarify what you're asking.
Could you not have asked the alleged victim to step out of the vehicle?
I was asking the driver to step out. I can pick whichever one, and you were refusing to do so. You were the one that was making the threats. I think that it's more pertinent to separate you from the situation than anything.
You keep saying that I was the one to make the threats. Is there any proof that I made these threats?
I had a call for service that you were making threats. I was investigating those threats that were made. That's what I was there for.
So you believe those threats was made by me?
I didn't arrest you for domestic, but because I didn't have any cooperation, but there was a reason that I was called out there.
So you didn't have any proof, correct?
A domestic arrest was not made due to the uncooperation of the victims.
Okay. You believe that there was a victim actually in this for the call?
I wasn't called for no reason.
Do you, but like when you, from your own personal knowledge of the scene when you arrived, do you actually believe that there was a victim? Like, do you believe that someone was beat up or threatened or in fear for their life?
That's what I was investigating.
So when I'm asking you, do you believe that she was a victim?
Turn your microphone on, please.
Judge, I'm going to object to relevance at this time. There was no charge for domestic, and so this really doesn't pertain to the motion.
Mr. Vaughn, the objection is as to relevance. The officer has testified that she was investigating a domestic violence case, or at least a domestic violence call, which means that she was there to investigate. Whether she believed there was one or not, that is irrelevant. The question of whether there was or was not one is technically irrelevant, because if she is responding to a call of a possible domestic violence, that is her reasons that she's testified to for stopping the vehicle and engaging with you. And at that point, her personal belief as to whether or not there was or was not a domestic violence is not relevant. So I sustain the objection. You may ask your next question.
I'm going to object to that, Your Honor. The relevant said the case. I mean, it was for a domestic to see how she approaches the situation. Domestic involves the entire case. It all stemmed from the original call. So there is some relevancy to the fact what was she visually seeing. I mean, she's later on making statements like, what is your view of everything? I want to see, how do you see things? Like, she should be able to answer that question, Your Honor.
I've sustained the objection, Mr. Vaughn, and so I consider your argument. But an officer who is responding to a call almost never knows for sure what is taking place. They're there to investigate. That's the whole purpose of the investigated stage of a criminal case. An officer who responds to a call is given a limited amount of information. They are responding to it in order to make that investigation to determine whether there was or was not a crime committed. And that gives them the opportunity, the probable cause to engage with a citizen and to talk with the citizen about that investigative stage. And then if they determine there is a crime being committed, then they can do that. But that also allows them to investigate and engage a person. And if they determine that that person has committed a different crime than domestic assault, then the law allows them to engage and charge that person for that. So I have sustained your objection of the state, and I'm instructing you to ask your next question. I've noted your objection, your disagreement with my ruling, but I am telling you, you need to move forward. You preserved your objection, so let's move forward.
Do you believe that you was emotionally attached at any time during this arrest?
What was your question?
Does she believe that she was emotionally attached any time during the arrest?
Emotionally attached? Can you
Yes.
clarify?
You responding to a domestic violence as a female to a domestic violence on a female. Do you believe that you were emotionally attached in any way, form, and fashion?
I was doing my job.
Okay, so that's a no.
I was doing my job. I don't hold any personal feelings towards my job. I have a job to do and a law to abide by, and that's it.
Okay. Do you recall making a statement that I believe that she is a victim?
I do not recall.
Did you at any time see that you had to have de-escalated the situation between you and I at the scene?
If you would have stepped out of the vehicle the first time I asked, there wouldn't have been escalated.
So there was no other option to de-escalate after that? Once a situation occurs, there is no de-escalation after that?
What are you asking?
After I stepped out of the vehicle, there was words back and forth. Did you feel like we needed to de-escalate further?
I don't feel like that there was a further problem.
Okay, when we got to the jail, we walked in the jail. Why didn't you take the handcuffs off when we walked in the jail?
We don't take the handcuffs off, the jail staff do.
Okay. When you see that I was agitated, did you feel like that was a de-escalation situation?
You were in the custody of the jail at that point.
Oh,
I just needed my handcuffs to leave.
So you were assisting them when you placed your hands on me?
I briefly held your arms, your one arm, to assist them because there was just one or two people right there. So until they got more people, whenever they had more people over there, I stepped back and took my hands off of you.
You said they only had how many people again?
Originally, there was only like one or two people right there. That's why I was assisting. And as soon as more people came, that's whenever I stepped back.
Was I resisting them? Or was I putting up a fuss or fight with them at this time when you intervened?
Yes, sir.
You stated that the reason you didn't take the handcuffs off when you came in the jail because I was in their custody. That means that your responsibility ended at the time, correct?
I'm not just going to stand there and watch somebody fight and resist from someone and put them in any type of danger. No, I'm not.
What do you call fighting and resisting? What does that look like to you in your own words, please?
Can you clarify?
What does fighting and resisting look like to you? Like if you see somebody fighting and resisting, what does that look like to you in your own words? Can you paint the court a picture, please?
Resisting would be preventing them from removing the handcuffs is what was happening.
So pulling away, maybe arguing. Okay.
Making those threats, pulling away, tensing up to where they couldn't remove the handcuffs.
Okay. You stated that earlier along the lines of, I made the statements of, I'm gonna beat you up, B, correct?
Yes, whenever she was asking you to stop tensing up, that is what you said.
Was I speaking to you?
You said You said that out loud. You did not say that directly to me,
Oh, so
but
I
I was
didn't
right
direct
there.
it to you, but you believed it to be towards you?
Absolutely.
Okay, do you also recall? You made a statement, it's on my other notebook. This one? You said you made a statement to me as we entered the jail, when you said that I allegedly said that, I am a threat. You made the statement. You said like you were threatening me, but it's cool. What do you mean by that statement?
Whenever I was walking up to the jail counter, I made the statement that I think, if I recall correctly, you said something about not threatening, and I said it seemed like a threat to me, but it's cool. If I recall correctly, that's how it was said.
Yes, and what did you mean by it's cool?
That it's fine. I mean, you're going to threaten me. Later on, you made a very thorough threats.
Let's stick to the question I'm asking you. So what you said it was cool. Like, does that mean you feel harmful? Does that mean that, well, oh, that ain't nothing, you're just talking, or what does that mean to you?
It's cool. You made the comment. It's cool. If that's what you want, do you want me to answer?
You can go ahead.
Okay. What I was saying is that it's cool. If you want to threaten me, then you can threaten me.
You just blew it off your shoulder, basically. Would you please use your words?
You stated you were a threat. I said it felt like a threat, but it's cool.
So you blew it off. Yes, correct.
I'm not saying I blew it off. I'm just saying that it's cool. If you want to threaten me, you can threaten me.
Did you feel threatened at any time?
During that whole encounter, up until me leaving the jail, yes.
So do you normally laugh when you feel threatened?
Sometimes, a little uncomfortable.
When you feel uncomfortable?
Yeah.
Okay. So do you recall the statement, he's just acting tough, he's just acting bad? Is that normally like a fearful statement?
I believe that your demeanor changed from the time that we were coming in. Like when we went into the jail, your demeanor changed. And then when you believe that when they were trying to take the handcuffs off, you were acting completely different. Yes.
Do you believe that I would actually retaliate against you?
I do.
You do?
Yes, sir.
So if you believe that, then why did you take so long for the charges to get filed for retaliation? It's 5 months after your arrest.
To be completely honest with you, I didn't know that that was a thing. If you want me to be completely and totally honest with you, when they made me aware of that, I was like, oh, I didn't know that was something that could be added on.
So it took you 5 months to figure out that you felt in harm and fear?
No, I did not know that retaliation
Mr.
after
Vaughn,
the fact was a charge that could be used.
To explain that, she didn't bring the charge. The grand jury returned this indictment. So it's not that she went to a magistrate and obtained a charge 5 months afterwards. The new charge was added by the grand jury when it was considering the driving on a revoked license and the resisting arrest. They added the third charge after hearing testimony.
Well, what I want to ask her next was, why didn't she file it then? You had 5 months. She made it in her statement. Her statement was on time.
Then ask that question.
Okay. So once you found out about the resisting arrest, that it was a possible charge that you can charge, why didn't you file it?
I was well aware that resisting arrest is a charge.
You was well aware that it was?
Resisting arrest? Yes, sir.
No, I'm sorry, excuse me, retaliation.
I was made aware during the grand jury proceedings.
Okay, so that's why you didn't file it, but you just took note of it in your report. That was the only reason, just for future reference.
For the notation of the threats that were made in my original report, yes, sir. I notated in there just in case some further incident happened. Absolutely.
Okay, was there ever any actual retaliation tried by me or anyone?
I've never seen you other than that incident and in court.
No calls, no threats, no nothing, no contact whatsoever?
No, sir.
Okay. But you believe that a retaliation was still possible?
Absolutely.
Okay. How long after the encounter with me did you decide, before you found out that I was allegedly driving unrevoked?
What are you asking?
After the first contact you made with me, how long did it take you to find out or find an alleged driving unrevoked charge? Was it before you placed me in handcuffs or while we were at the jail?
While we were still on scene, I met with the magistrate before we ever went to the jail.
You met with the magistrate before we went to jail?
Yes, sir, at the police department.
Yes, that's when you found out at the jail?
No, I found out on scene that you were revoked from dispatch. So at the time that you were transported, I was well aware that you were revoked.
Okay, would you say it was about 15 minutes, 20 minutes maybe?
I don't know the length of time, but I know prior to you being transported, I knew that you were revoked.
Okay.
May I briefly?
You may.
You're fine. It's Lindsay Javens.
Your rank, I'm sorry.
Oh, corporal. I'm sorry.
Okay, I always do that. So when you say on scene, you still consider the police department to be on scene until you actually get to the jail, is that?
No, sir. I'm saying on scene as in Dollar General. I knew he was revoked before we left Dollar General, before he was transported to the jail to meet the magistrate.
Okay, all right. And that is driving on revoked or suspended, that is a catch and release statute, correct? You could have issued a citation, correct?
Oh, okay. I see what you're saying. We can issue a citation unless it's significant numbers. There's clarification of time that we can and can't issue citations.
Significant numbers.
Like if someone has 4 priors or 5 prior driving on revoked, that's indicating that the likelihood of the offense is going to continue if they continuously are getting driving on revoked charges.
Okay.
So that is an exception to the citations.
Did you note that in the warrant?
I'm not saying that that was applicable in this situation. I was saying that that's a time that they wouldn't be arrested.
But if somebody,
they would be arrested, not a citation, sorry.
Right. And Miss Dozier, Dozier, I'm not sure. She was present, right?
Yes, sir.
Did you run her driver's license?
I believe so, yes, sir.
Was it valid?
I do not recall.
She drive off from the scene?
I do not recall.
She wasn't placed in custody, though.
She was not taken in custody, no, sir.
So, in theory, she could have driven away from the scene in lieu of Mr. Vaughn.
If she had a valid driver's license, yes, sir.
And you issued the warrant primarily on this resisting theory.
Resisting and driving on revoked.
Okay. But you determined the resisting first, right? You determined that you were going to charge with the resisting first in time that night. Then the driving on revoked.
They were presented to the magistrate at the same time. He was.
But you, in your mind, you witnessed what you would say. Did you run his driver's license before you placed him under arrest for resisting?
I believe that he was placed in handcuffs after I got him out of the vehicle and put him at the car. At the point where he was transported to go meet the magistrate, I was well aware of the driving on revoked and the resisting.
Okay. You didn't run her driver's license?
While on scene, I typically would log all parties, so I believe that it was logged. I just don't recall if she was valid or not.
Okay. But your report says you couldn't determine who the aggressor was in the alleged domestic, right?
I could not determine that there was a primary aggressor and that an assault occurred for the domestic.
Right. Okay. So absent this resisting charge, it's likely that you would have issued him a citation and let him go, right? Had he not done what you perceived to be resisting arrest. And let her
Possibly so.
drive.
Possibly so.
That's possible.
Possibly.
And had he not been out there cuffed up in handcuffs, these statements are never made. This evidence is never obtained, is it? For this charge that you didn't know existed. Correct?
Can you clarify what you're asking?
If he's never arrested for resisting arrest and he's issued a citation in lieu of arrest, and Ms. Dozier is allowed to drive away from that scene, and Mr. Vaughn is never in cuffs and taken to the sheriff's office out here where the jail is, correct?
Yes, sir. Correct as in that's where the jail is.
Well, in that scenario, he never would have been taken there that night by you either. That's correct, isn't it?
He was taken in custody for driving on revoked and for resisting. That was presented to a magistrate and probable cause was found, warrants were signed.
Understand that, but that's what I'm asking you. You would have been able to issue him a citation if not for the resisting charge, right?
You're asking a hypothetical situation. I'm telling you what occurred. That's what occurred.
Asking you, okay, then let me ask you specifically, had he not resisted, would you have issued a citation?
I could have possibly issued a citation.
Would you or would you not have?
Depends on the situation, the circumstances, how many priors he had.
The circumstances as they were that day, how would you have done it?
The circumstances, how they were that day, I would have done the same thing that I did.
Absent the resisting portion that you claim was resisting, and you came up there and nobody wanted to talk about you about what you perceived as a domestic, would you have just simply issued a citation to him? Take out the resisting part.
Yes, sir. Like I said a second ago, that is a possibility that could have happened.
Okay. And had you done that, he would never have been cuffed up, would he? In the event that you had issued a citation, right?
Are you saying that he never would have went to jail? Is that what you're saying?
Yes.
Yes. If I issued a citation, I do not take someone to jail. That is correct.
Okay. And at that point, you're not having to get your handcuffs back, are you?
No, sir.
And he's not making those statements, is he?
If we're not at the jail, that's a hypothetical situation. If he was not issued a citation, if he was issued a citation, we would have never been at the jail.
Okay.
That helps.
And you have count two, that resisting has been dismissed, right?
They elected to dismiss it. Yes, sir.
Okay. And you put your hands on him and all he said is, I'm not getting out of the car, right?
I
You
opened
the door
and then we got out of the
put your
vehicle.
hands on him. At which point, Mr. Vaughn then showed you before you do that, before you do that, he had a weapon on him, correct? And he showed it to you. Was there a knife?
Yes,
right?
sir.
So he was making sure that you were aware of the circumstances, right?
Yes, sir.
And so you didn't misinterpret his intentions that night, correct?
Misinterpret what intentions?
Well, he wasn't charged with an assault against you, and a knife can be considered a deadly weapon, right?
Yes, sir.
So if a suspect concealed a knife, then that would be a charge. He didn't conceal that from you at all, did he?
He made me aware that he had the knife.
Okay. And had he not, and you found that on him, that could be a basis for some sort of assaultive offense, right?
For having a pocket knife?
If you were afraid of it.
No, sir. I would not say that would be an offense or an assault to have a pocket knife.
But he was being cooperative and telling you in advance that he
After
had
the
that knife.
After the fact, yes, sir.
And you did go out there and said it's cool after he talked to you the first time, right?
After he told me that he was a threat.
Well, after what you say, he said, sure, if that's what you say, he said, you said it's cool.
Yes, sir. That was before the next two statements.
Okay. But at that point, you didn't feel threatened by saying if you said it's cool.
He's said I'm a threat.
And you said it's cool, which would not be indicative that you felt threatened, would it?
No, sir.
Okay. And you, I believe, said that you became threatened after Corporal Stewart made you, or you felt more threatened after Corporal Stewart told you what he said after you were gone, right?
No, sir. That's when we spoke about what he told to Corporal Stewart as well. That's whenever we talked about making sure that it was documented in the report.
Okay, so Corporal Stewart's statements about what he said is those didn't play any factor into you adding this charge at grand jury?
It contributed to the whole circumstance, yes.
Okay. And you heard Corporal Stewart testify the other day, right?
Yes, sir.
Okay, and you were not, your name was not mentioned specifically whatsoever in what Corporal Stewart heard. All that.
There were no names mentioned to my knowledge.
And so there was no direct threat made, indirect or direct threat made at you specifically. Based on simply based on what Corporal Stewart heard and testified to.
If I recall correctly, he testified that he took the threat to be to law enforcement.
But law enforcement's not named as the victim in this indictment. You are.
I am law
specifically.
enforcement,
Okay.
technically.
But you're the only one that's named in this indictment.
Okay.
And your name was not mentioned specifically whatsoever.
He did not specifically say my name, no, sir.
Okay. And you're only, and you said you ran his driver's license on the scene at Dollar General
Yes,
before you went to the police department?
Yes, sir.
To the magistrate? Okay. And I know I've gone over this, but you had already had in your mind that you were going to charge him with an arrestable offense, right? That's why resisting arrest, you're going to get warrants. You saw what you perceived, at least, as resisting arrest on that scene, right?
Yes, sir. I believe that he was resisting and he was driving unrevoked. He was taken in custody and that was presented to the magistrate.
And the resisting would nullify nullify the practicality of issuing a citation for the driving on revoked, because you're cuffing him up anyway for resisting.
As I said, that's a hypothetical situation that he could have been issued a citation, yes, but there were other things I would need to look at. If it fit any of the exceptions, then no, he wouldn't have been issued a citation.
Well, he wasn't going to be, because you were going to arrest him for the resisting. So it wouldn't have been a need for a citation anyway, would there?
Brad, I think you've asked that question about 5 times.
Yeah.
And I've not, believe Your Honor, gotten a direct answer.
She's answered it in the form of that under the facts of the circumstances, this is what she did. If she could have issued a citation, she said that. If she'd issued a citation, he would not have gone to jail. If he hadn't gone to jail, he might not have been charged with retaliation. All of that, you've made that point several times. Is there some other question that you want to ask?
No, Your Honor, not specifically on the point. I just wanted her to answer me as to the citation was less likely to be issued because she had what she perceived as an arrestable offense. I don't think I've gotten a straight answer to that.
Well, with the citation, I'm sorry.
Go ahead.
With the citation being issued, if I'm going to issue someone a citation, I have to make sure that it doesn't meet those exceptions. If it meets those exceptions that are outlined in the law, then I can't issue a citation and I should take them in custody.
Did you go through those exceptions that night?
No, I did not, because there was resisting and a driving on revoked.
I think that's what I was asking. So.
But you're at like a hypothetical situation of for sure that I would issue a citation. I can't say that. I absolutely would have issued a citation if it met those situations, the exceptions in the law, then he would not have been issued a citation.
But you never got to those exceptions because you had mean, I think that's what you just said. You never checked those exceptions because you're arresting him for resisting.
He was arrested for both, yes, sir.
Okay. Those are my questions.
General?
Is laughing sometimes a form of de-escalation?
Yes, ma'am.
Now, you talked about those exceptions under the law. One of the exceptions to citation in lieu of arrest is if someone, if there is a reasonable likelihood that the arrested person will fail to appear in court.
Yes, ma'am, that is.
And you didn't look into how many FTAs Mr. Vaughn had because you were already arresting on something else. Is that right?
That is correct.
If someone has multiple failures to appear on their criminal history, would you issue a citation in lieu of arrest or would you arrest?
I would arrest if there was a likelihood that person would not appear in court.
Nothing further, Judge.
Anything further for this witness?
Corporal Dravens, you have been asked by both the defendant and elbow counsel multiple times on the timeline of when you realized that the defendant was revoked. Have you watched your entire video start to finish to be completely sure of the exact moment?
No, ma'am.
Do you even know if it's going to be on your video when you find out that he is revoked?
It could be, but during the investigation, I ran, his license and I was informed, and I know that was before I would have went to the magistrate.
Yeah, before you went to the magistrate, you found out that he was revoked.
Yes, ma'am.
But you don't know exactly what moment.
Not the exact moment.
So just throwing out the possibility, it is possible that it wasn't until you got to the police department with him.
Could be, but I would say that I knew on scene.
Okay. Nothing further, Judge.
All right. Anything else?
The same question she just asked you about the time limit on the arrest. Would you say 30 minutes is roughly too long to find out if someone's driving on revoked?
I don't have a timeline on the amount of time that I knew that you were revoked.
Is there any policy or proper procedure that you go by to stay in lawful to a pullover?
Well, I cannot detain someone for longer than reasonably necessary, if that's what you're asking.
Okay, would you say that reasonably necessary after I was placed in the back of the car and we were leaving the scene, do you think that was would that be considered a reasonable time?
Can you clarify what you're asking?
Once you decided to place me in the back of the car and we were leaving the scene, would you consider the investigation done, that was the reasonable time to end the investigation? Or should we take it to the police station and continue an investigation?
You were taken in custody and it was presented to the magistrate. I'm not sure what you're asking.
You're familiar with the what you think a reasonable time would be, correct?
It depends on the circumstances.
Okay, so do you believe that when we left the scene that the investigation should have been concluded?
You were taken in custody.
Yeah, so does that mean that the investigation prolongs after that custody? I mean, if you choose to investigate anything, are you required to, do you feel permitted to go on further past that? If you take me into custody and you want to keep investigating, is that okay?
Can you clarify what you're asking?
All right, when we left the scene and got to the police station, is it okay to continue to investigate?
Absolutely.
Okay. So what I'm asking you is, when we left the original scene before we got to the police station, you were not finished with your investigation?
You were taken in custody and you were transported there. If I didn't know that you were, I believe that I knew on scene, but if you're implying that I didn't know until we got to the police department, they were presented to the magistrate at the same time. I don't know that that's relevant.
It is when it comes to, well, I can't make statements. But that'd be all, Your Honor.
Anything?
One more, I believe, my assistant.
I allowed him to assist by asking a couple of questions, but that's not the role of elbow counsel. The Tennessee Supreme Court in State versus Small, which is at 988 Southwest 2nd, 671, defined the role of elbow counsel. When you have elected to represent yourself, then you have waived your constitutional right to counsel. It is within the court's discretion to appoint elbow or assistant advisory counsel, which I have done. And the role of a advisory counsel, also known as elbow counsel, is an attorney who functions in a purely advisory role to a pro se defendant without actively participating in a trial. Pro se defendant who is permitted to such counsel may consult with the counsel for guidance and advice, but otherwise handles the defense of his case on his or her own. So Mr. Spratt can sit there and give you advice, and that is his role. He's not going to be allowed to question witnesses and otherwise make statements or have any other role other than giving you advice, because you have waived your right to counsel. So.
Okay, can I seek advice from him then?
You may.
Your Honor, I'm gonna ask you permission to since Ms. Danny Bryson brought up the video, that I'll be allowed to play the video in open court.
Do you have any other questions for this witness? You want to play the video in your response to the state's evidence? Is that what you're saying?
Yes, sir.
State have any objection to that? Then we'll allow that to take place. I just want to allow the officer to step down if you have no other question.
Is it possible that I could play the video to ask her further questions about what she views in the video?
Let's let the officer step down. Do you have any other witnesses?
Judge, I think the video may be being played at attempt at impeachment. And so if so, she would be able to respond after it's played.
Well, let's bring the video up and let's get it hooked up, and we'll allow it to play it if it's part of his cross-examination. Who hasn't? Who is playing it, I guess is my question. Mr. Spratt? I'm going to step off, take a short recess while we try to get this queued up. Let me know when you're ready.
All rise. Court is in recess.
Let's,
All right, we're pulling the delegate now. Hello. How you doing? Good. How about I come back here and talk to my equipment?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
Call for a domestic. What makes a domestic?
I got you. Somebody just called. Let me come back here and talk to you real quick. We'll talk about it.
I can't step out of the vehicle until I
You
commit the crime.
can't.
I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims case law says anytime I tell you to step out of the car, you step out of the car.
But you also know.
Case law says, no. Case law says if I tell you to get out of the car, you get out of the car.
Can I have a
So get out of the car.
come to work?
Well, they're coming. You're gonna get out of the car when I ask you
I'm comfortable
to.
right now because as a female person, it's a male domestic. I've been in this
I'm
many
not,
times.
I'm just trying to talk to you.
Okay.
You're making this a thing.
No, I'm not.
Step it up on me. I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're gonna talk to you separately. That's how we're gonna go. So I'm gonna get you to step out of the car. But listen, go on. You're gonna step out because I'm telling you to step out now.
Where am I gonna stand? And am I under arrest before I step out of my private vehicle?
You're not under arrest right now. I just need to
Then
talk
I
to
have
you.
no reason to step out. I'm still not under arrest.
Step out. You're gonna go to jail for resisting. The second I put my hands on you and you don't get out of this car, you're gonna go
You do
for
not answer
resisting.
correctly. You know this.
There ain't nothing about it. I just told
I'm
you.
not under
I just
arrest. You
told
have no
you.
reason to touch me.
Case law says if I tell you to get out of the car, you get out of the car.
You say I'm
It is.
under arrest.
Get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car. Get out. Get out.
Wait, hold on. Grab that before
You're
you
good.
touch me.
You're good. Ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's two males in that car.
I want a male to touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's gonna be a male that's gonna touch you. Put your hands on your back.
Please touch me.
There's gonna be a male that's gonna touch
A
you.
male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
She's not being disrespectful.
You've been disrespectful since
I asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Why am I
Did I tell you to get out of the car? Did I tell you to get out of the car?
Am I under
Get
arrest?
out.
Am I under arrest?
Did I tell you? Now you are.
I reserve
Now you
my
are.
rights.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, please.
All right, ma'am. You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got you. I got you. Well, there's enough that's already. Listen. There's a.
Your Honor, I would like to stop that right here and request now the time to ask some follow-up questions.
All right. Officer will return to the stand.
Your Honor, I would also like to request that the courts move that into exhibit as a hearing.
We will mark it as an exhibit to this hearing after the conclusion of the playing whatever portion you intend to play. In the state may elect to play more of that. We'll see. But you may go ahead.
Okay. Up to this point of the video that you've seen, would you classify that as the resistance that I was arrested for?
Yes, sir.
You would. At this time, did you go through the cite and release for the arrest, yeah, the cite and release, did you have time to go through it then?
At that point in time, resisting. I asked you to step out. I told you when I had to put hands on you to get you out. And whenever I reached to help get you out, you jerked away from me and then went to get out.
I jerked away from you in that video?
You pull away. As soon as I touch you, you pull away. I mean, if
You sure I wasn't reaching for a seatbelt that was across my chest? To unbuckle the seatbelt and get out of the vehicle?
if you'd like, I mean, it's up to you if you want to play it again.
It's up to you. I'm the judge. If he would like to see it again, I'm familiar with it. It's up to you if you would like to see that again, Your Honor.
Do you want to see it again? I don't think it's necessary that we replay it again. She's answered your question, and this is not an argument between the two of you. This is question and answer form.
Yes.
So ask your next question.
One second, Your Honor, may I speak to my counsel? The segment of the video that we just viewed, so would you agree that I was arrested for refusing to get out the vehicle at this point?
For resisting, yes.
Yes, that's the only thing I was at this point in the vehicle.
Something that you're doing now, both as a second time, but this is a lifetime agreement that you both will enter into it. And with love and with patience, it will last a lifetime. You know, you will affirm this bond together publicly and at home with with each other as well. So whether it be dinner at the restaurants that you go to on Sundays, where someone, when you guys want to go, the other one don't, just appreciate each other, and it will go and last a long time. It is time to joyfully seal this chapter today with the declarations that you both have for each other. Do you, Abby, and do you, Rob, both of you, to be your lawfully wedded partner, to have, to hold in sickness and in health, in good times and not so good times, for richer, for poor, commit yourselves onto each other for as long as you both shall live?
Yes, I do.
I do. Okay.
Judge, there's no, we don't see any of them.
Okay, can I get you?
Right.
Oh, yeah. I wasn't sure. I don't see anyone in the waiting.
Yeah, the camera's right there. If you guys want to center yourselves. Okay, there we go.
Oh, I guess people just watch. I don't put them in.
Yeah. Right, I told them the live stream. Yeah.
Thank you.
Yeah, because I'm sure nobody will see.
Better than the dead stream.
Yeah.
If you want to sit around, look a little bit more.
No, it's still late. It's still late.
Oh, it's still late. Oh, we're good. Cool.
Okay, are you ready?
Mhm.
Can we keep going?
Is it the back?
We're just waiting to make sure everybody's censored. Just catching up. I'm assuming your head has me.
Yeah, I was like,
Yep. your head has me.
Okay.
okay.
I think they're good now, Judge.
Okay. Ready? Okay, here we go. All right. Your wedding rings are a reminder of the vows you two make for each other today. A ring is an unbroken circle. It ends that have been joined together, and it represents a union. It is a symbol of infinity and of your infinite love. It encircles an opening, which is the door to your future. When you look at these rings on your hands, be reminded of this moment, your commitment, and the love that you both feel for each other today. So who has the rings?
I do.
Okay, if you want to give one to him and
Here, you
you
want
guys
that
can
one?
exchange.
There we go.
Okay, Abby, if you want to place the ring on
Yep.
Rob's finger.
Whoops.
I give you this ring
I give you this ring
as a symbol of my love,
as a symbol of my love,
with the pledge to love you today,
with the pledge to love you today,
tomorrow,
tomorrow,
always and forever.
always and forever.
And Rob, if you want to put the ring on Abby. I also, Abby, give you this ring as a symbol of my love, with the pledge to love you today, tomorrow, always and forever. Now that you, Abby and Rob, have promised to give yourselves to one another, to the love each of you through your sacred vows and through the giving and receiving of these rings, by the power vested in me in the state of Texas, I have the great honor and pleasure to now pronounce you married. You may now seal this with a kiss.
Oh. Aw, thank you so much.
You have the marriage certificate?
Yes, we do.
I need to sign.
Thank you, everybody.
Thank you.
So glad to be part of it.
Congratulations.
Glad we made it. Whoa.
Or my condolences.
Nah.
Little early for that.
We have been married 44 years, 44. Valentine's Day will be 45 years.
So my handwriting is a little messy. I don't know if you want to put the date there.
Yeah, I'll put the date there. I think they're gonna give us a different one.
No.
9, 18.
I forgot what your year was.
They're gonna give us a different one when it's all said and done.
Mom's parents.
Yeah, a long time, huh? Long.
Awesome.
I'll get out the way. 46. Nothing 46.
So, but this is gonna get me. I'm never wearing these shoes again.
I've been to. The other one was a relative.
Victoria. And you're Robson? Oh, I'm a friend. Friend. There you go.
I'm the older brother.
I hear that.
Thank you so much.
I didn't have.
Oh, that's for you, but
Congratulations.
thank
guys.
you so much. Wow, now we're gonna go,
Are y'all taking
Like
a trip?
Wait, what else?
we're going
Yeah,
to Smoky Mountains
crazy.
for my dad and my sister, so they can, we're gonna do a smaller wedding there. And then, I think next summer, we're gonna go to Big
Yeah,
Bend,
I think I do
because he
too
wants to see the
somewhere.
Milky Way.
I just don't have a
And then
DVD
the year after that,
anymore.
we're going to
He's
Sweden.
more outgoing.
For- Yeah, for mid.
He's more like.
Yeah. Yes.
I
Yeah,
get it.
so we went
I
to
see
India for
that.
their
Well,
big
that's
party.
good.
We're gonna
Me
go
so
to
much,
Sweden
not
for
so
their big
Yeah.
summer party. And
Well, that's
I've been taking Swedish lessons.
Yeah.
Hopefully.
I was in this.
Yeah.
Great.
Yeah, it'll be a lot of fun. but-
Thank you, Judge.
Yes.
Well, when we
Leather
married,
jacket.
Yeah,
he
I
was
know.
the
yeah.
outgoing one, as you would know.
I
And I was shy, quiet, and whatever. I said these are all too.
I was
Part of the action.
Yes.
So school authority here, she is our court
School
liaison officer. She's on
attending is
probation.
hard.
I met with a lady.
Oh, yeah.
Oh, I graduated senior year in 9/11.
And so.
When
this
did you
is Ray.
graduate?
I senior year in 9/11, same year,
Oh.
3 months, 5.
Well, he.
That's
has
when
his
you graduated?
June.
She's got
Wow.
things, we have bailiffs over there.
We graduated in 1974.
A year before, our mom graduated. Year after.
Yeah.
Yeah.
This one is I realized the other day, last year was our 50 years. They didn't have a reunion.
I went to more of mine.
Have you done, we did one, that was
You
it.
can see, so, here, this is
All
where the
right.
jury would sit and listen to all the evidence, witnesses, and then when we have people, we put them in jail, that's where they go down there. So if you guys want to go take a look, you can go look in the jail.
I seen the one with the handcuffs earlier.
Yep. And if they really misbehave, the handcuffs stay on and this is where they go.
Okay, Joe, be careful.
Don't forget we had a cousin like that.
I'm a lawyer, I'm a true crime, I watch all the trials, I do all the stuff, so when I found out working with the courthouse. and
Oh, I used to watch the judge stuff.
Great.
All right.
Oh, I was.
So control if you add me or something too.
Oh,
So here, they will go down here.
Yes.
Over here.
Lock them up.
All the way downstairs.
All right, close it, lock it.
So that's what here. Here.
At the point where we're paused right now, there was resisting. I said you're going to be arrested for resisting at minimum.
Okay. I believe that's all, Your Honor.
All right, are we playing any more of this video? All right. Thank you, officer. Do you have any further questions for the officer? Thank you, Corporal. You may step down.
Yes, sir.
All right, you may call your next witness. General State is putting on their proof. On this 336 indictment, the state has rested their proof on your motion to dismiss or suppress. You now have the option of putting on proof of your own. Do you wish to offer any proof?
Yes, I would like to make a note of the video first, Your Honor, if I could.
You want to?
I want to clarify that that was just the first 3 minutes of the video.
That's fine. Well, we're going to make the video an exhibit to this hearing.
Excuse me, Your Honor, I didn't hear that, please.
We're going to make the video an exhibit to the hearing. And you're going to have to designate the first 3 minutes. Is that what you said? Is the portion you're relying upon?
3 minutes and 6 seconds, yes, sir.
3 minutes and 6 seconds are the portion that we're relying on, that you're relying on. All
Yes,
right.
sir.
Then it'll be noted on the record.
Yes, sir. I would like to call my witness now at this point.
Who?
Jennifer Dozier.
All right.
Just go.
I'm sorry. Time for you to ask one.
At any time, did you Mirandarize me?
I'm sorry, repeat that.
At any time, was I Mirandarized?
Were you what?
Mirandarized. Did you read me my Miranda rights?
Not that I recall.
Not that you recall. Is that normal procedure too? When you want to arrest someone to read their Mirandarization?
Not every time, no, sir.
Not every time. With this situation, would you say cause for it? This arrest, pertaining to this arrest.
Pertaining to this arrest,
Would
no,
you-
I didn't need to, I don't think that I was asking you any questions related to resisting or driving on revoked. If I was asking you questions, if you were being interrogated, you would need to be advised of your Miranda rights, but you were not being interrogated.
Okay, thank you. That's all.
Thank you, Corporal. Hopefully this time you can stay seated.
Yes, sir.
Dozier, I need you to come around to the witness stand, please. And ask you to raise your right hand and let the clerk place you under oath. Thank you. Have a seat. Mr. Vaughn, she is your witness, so you may approach the podium and question the witness.
Okay.
Would you state your name for the record, please?
Jennifer Nicole Dozier.
Okay, can you hear her, Your Honor?
Barely.
I'm sorry. I started this 2 days ago and it still hasn't cleared up.
Just pull that microphone to you as close as you can and then try to speak directly into it.
Jennifer Nicole Dozier.
Okay, I can't remember the exact, but the night of this arrest for this case with Officer Jarvis here, do you remember that night?
At Dollar General.
Yes.
Yes.
When I was asked to get out of the car, I know you're saying your area of expertise. Do you believe that I pulled away from her or pushed or gave her?
Not to my knowledge. You stated that you wanted a male officer because you didn't trust female officers.
Okay. Do you, was you ever, I'm trying to state this question the right way. Was you ever asked for your driver's license at the scene?
Not wrong.
You don't recall? So you don't know if you have, so do you know if she ran your name or?
I'm sure she
to
did.
see if
They
you had?
usually do on like recalled it.
Okay. Did you have a valid driver's license that night?
Yes.
Okay. I believe the last question I have, is there any reason that you believe that, that you want to tell the courts of why I don't trust female officers at the words you said?
Yes, because we've had
Pull that microphone towards you closer so that at least we can try to hear you.
that a little better.
Okay.
Yeah, I mean, you said you had female issues with female officers before. I'm sorry, I'm struggling here. You said you had issues with female officers before because of that domestic, and the female officers all came out a long time ago.
Okay. I believe that's all I have for you, Your Honor.
All right. General Bryson, you have any questions?
No, Judge.
Thank you, ma'am. You may step down. You can have a seat in the courtroom, or you may go out in the lobby, or you may leave. Mr. Vaughn, you may call your next witness.
Yes, Your Honor, I don't have any more witnesses.
All right. Now, I'll hear you in argument. This is your motion, so you may argue your motion to suppress.
Can I stay seated here and argue it, Your Honor?
That's fine.
Thank you. This is a motion to squash, to dismiss with prejudice and suppress evidence. Citations under the Fourth Amendment, under the Tennessee Constitution, Article 1, Section 7, and TCA Code 47103A1, and also under the Fifth Amendment for Mirandaization. Oh, this is one case. Okay. Resisting arrest is a charge that my lawful actions does not fit the crime, therefore should the counts be dismissed. State versus Burgess, quoting, State versus Corridor, concluding that the defendant not moving and directing obscene language at officers were not sufficient to support a conviction for resisting arrest. Also see Tennessee Attorney General articulating that passive interaction, specifically sitting in a car and refusing to exit, was not resisting. Again, a lack of cooperation in service or process is not a criminal offense, quoting Burgess. The defendant has no legal obligation to facilitate service or process or other cooperation with deputies by accepting service or process, quoting Burgess. The officer had other means of effecting service or process available to them, but elect not to pursue them. His actions did not foreclose the deputy's opportunity to serve and to merely constitute a lack of cooperation with the deputy's chosen method of service. When a detention arises to the level of full-fledged arrest, the Fourth Amendment demands that the seizure be supported by probable cause. So a seizure occurs for probable cause under the Fourth Amendment when the police detains an individual under circumstances where the reasonable person will feel that he or she is not at liberty to leave. Haynes versus Florida. It says, the officer continues detention of the defendant in the back of a locked police car has ripened the investigation, stopping to an arrest, and the officer did not have probable cause to arrest the defendant at the time the seizure was illegal. United States versus Richardson. The police crossed the lines of the investigation into an arrest when they placed a suspect in the police vehicle for questioning ongoing beyond the bounds of a Terry, crossing into an arrest and constitution of seizure. It says, on the night the officer detained me, no force or resistance occurred. With or before the citation mentioned and the Burgess case stating force is physical and obstruction and arrest requires force to be used against the officer. Therefore, the arrest is illegal. Being compelled to accept service after myself and Jennifer stated we do not need your services is unlawful. The escalation should have been the prime intent of the officer of a domestic. The music was up to stop the argument over the birthday cake. The officer could have asked Jennifer to get out of the car to check her for injuries since the concern was for her. These actions with her reaching in the window multiple times, placing me in fear, was just as every other interaction with females responded to domestic, it's bias. State versus Daniels. However, neither the Fourth Amendment nor the Article 1, Section 7 of the Tennessee Constitution limits all contact between police officers and citizens. Instead, the Constitution provisions are designed to prevent arbitrary and oppressive interference with the privacy and security of the individuals. That's quoting D'Angelo. It said the State versus Dowdy. Article 1, Section 7 of the Tennessee Constitution is identical in intent and purpose with the Fourth Amendment. Thus, these constitutional protections are implicated only when a police officer interacts with a citizen's and permissibly intrudes upon the privacy of the person, security of the citizen. That's my first argument for the dragging on rope. Do you want me to continue with all this, or do you want me to allow the state time to respond?
Well, that is your argument as to the resisting arrest charge?
Yes, sir.
Okay, I'm going to dismiss the resisting arrest charge, which I've already done before we ever began that hearing. So the resisting arrest charge was dismissed voluntarily by the state. So it has no bearing in this argument on this motion, except for whatever argument you might make about how that impacts the validity of the remaining issues. Any other argument?
Yes, sir.
You have a driving on a revoked license that you're facing, as well as the retaliation for past action. Those are two separate charges, and you have the right to, I would simply point out to you that the resisting arrest charge, well, I'll wait for you to, I want to let you conclude.
Okay. Also, I want to argue the fact that no exception to catch and release were explored because of the resisting. So, I believe I'm asking, may I ask a question to my sister?
But you make the argument, as I've said, all of this that you've argued so far has had to do with resisting arrest.
Correct, Your Honor.
And if you want to address your motion to suppress as to the driving on revoke or retaliation for past action, then I'll be glad to hear that. But as I've said, I've already dismissed the resisting arrest charge on the state's voluntary motion.
Okay. Well, the rest of these, the arguments I have also stem from the resisting arrest.
That's fine.
And I'm using the resisting arrest as a reason for that we should move for dismissal of the remaining charges. As tainted fruits, let me see.
Fruit of the poisonous tree.
Yes, sir. Let me just go ahead and read some of this. I'm gonna go on and read some of the retaliation right quick.
All right.
All right, for example, Mirandaization is triggered only on custody. So once I was placed in the back of the police car, matter of fact, once I was placed in handcuffs, I was in custody. And Miranda should have fell into a factor. And
Miranda requires that the officer Mirandize you, if you want to say that term, that you be advised of your Miranda rights before any in-custody interrogation.
Correct.
Those rights include the right to have an attorney, the right to remain silent, and so forth. There is no statement that's been introduced at this point that where an officer has questioned you or interrogated you while you were in custody, and if they had, then without Mirandizing you, then that the remedy is to exclude that statement.
Yes, sir.
But there is no statement. The statements that have been introduced were voluntary statements made by you, not as a result of questioning. That would therefore, Miranda would not apply.
Actually, it would, Your Honor. There was a question that was asked on the entering of the jail, and I have a case here. It's Travis Lester's versus United States, where it states that any encounter with an officer where they ask you any question is subject to Miranda, because any question that an officer asks can be considered as a listening and an illicit questioning that can be the fruits of a discriminating, I can't find my words, incriminating response. So Miranda would apply in this case, and I have this case here too, if you would like a copy of this, put in the record.
I'm well familiar with the Miranda rights and how they apply.
Let me see. Let me just read this. I believe this is good to be read in the court. It said, at no time was I informed of my rights, and I was questioned and answered at the alleged charges. Fear is not a factor when the officer is laughing and instigating the event. There is even a jailer stating, "You look scared" in the video. It says, furthermore, charging me days after, which we already addressed that in the court. The evidence before this clearly illegal arrest, the evidence and any statements used to make count 3 retaliation of past act never would have been obtained before that legal arrest. And also, I have a similar argument. The fruits of the poisonous tree that stem from that arrest, which is the exclusionary rule, encompasses both the primary evidence obtained as a direct result of the illegal search or seizure and evidence later discovered and found to be derivatives of the illegality, United States versus Anderson. Quoting Sarga. The wrong committed by the Fourth Amendment is fully accomplished by the unlawful search and seizure itself, and excluding the evidence could in no way cure the invasion of the defendant's rights, which he has already suffered. That is United States versus Leon. Instead of seeking for repair of one of the Fourth Amendment right, one violated, the exclusionary rule aims to prevent future violations of the Fourth Amendment by removing the incentive and disregard it. That is Elkins versus United States. And that's all in support of the fruits of the poisonous tree. State versus Blair. The proper remedy for illegal arrest is the suppression of evidence seized as a result of the arrest, not dismissal of the indictment. Says evidence, State versus Dotson. Evidence derived from such a search is subject to suppression unless the state demonstrates by preponderance of evidence that the search and seizure was conducted pursuant to an exception of the warrant requirement. And I don't believe that the state will have enough evidence to support that finding, Your Honor. And here's my argument for the retaliation. The state lacks evidence of lack of an intent. They don't have a intent, they can't prove an intent on my behalf that it was actually directed at the officer. They can't prove that there was an intent to do harm to her. There was no proof of none of that. There's no proof that any retaliation even exists. The act wasn't even motivated by retaliation. Just her touching me and telling her to stop touching me, that had nothing to do with her official capacity. The law requires that the retaliation be in response to an official act, testimony, an arrest, a prosecution. That was not the case here, especially when we just questioned her, she said that she gave me over to the custody of the jail. If I wasn't unlawfully committed into the jail facility to begin with, this just wouldn't even been a situation. There wasn't any link between the officer and her official role, lacked the intent. Oh, that's not the argument here. The officer wasn't intimidated, nor was the officer harmed. And furthermore, the arrest wasn't even lawful, so the act of retaliation doesn't even apply. And any responses that came out of me should be counted as emotional and not expressive, nonviolent, nor retaliatory. So my prayer is that the court sees my argument and move to dismiss all of it as tainted fruits stemming from the arrest itself, Your Honor.
All right, General Bryson, you may respond.
Judge, I'm going to approach this almost backward. The question that I see as almost deciding this is what would actually be suppressed here? So the state is going to trial on 2 counts, driving on revoked. So the evidence that the state would present in that is the officer seeing the defendant driving and the fact that his license is revoked. So no suppression would apply to either of those factors. Okay. The second count, or the second charge that is going to trial, is the retaliation for past action, which doesn't have to be actual physical retaliation. The threat of retaliation is what's being alleged here. And to follow the defendant's logic that let's just say this was a legal arrest, which the state does not agree, but let's just follow that logic. If this was an illegal arrest, by the defendant's logic that his statements should be suppressed as part of a poisonous tree, had he instead chosen to punch the officer in the face and commit an assault, that should be suppressed as well. He is essentially asking for permission to commit new offenses. This is not an interrogation with a confession. It is a new offense. And under case law, even if this were fruit of a poisonous tree, even if we were following down that line, new offenses are not going to be covered by that. They are attenuated from the original incident. And so we just can't go down that road and follow that logic that his new offense doesn't count. Because that's essentially what he's arguing. It doesn't count that I said these threats to her. We don't end up there. That logic doesn't work. So let's go back to this supposed illegal arrest. The officer, as she stated under Pennsylvania v. Mims, had authority to ask him to step out to investigate. Probable cause was determined on 2 different occasions, both by the magistrate and the grand jury, for resisting arrest. Okay. The defendant's behavior, she is asking him to get out. She does have to lay hands on him. Judge, the state chose not to go forward on that charge because there's a difference between beyond a reasonable doubt and probable cause. But the officer had probable cause to make that arrest. And moving forward, she had probable cause to charge him for driving on revoked license. Now, the question here is not whether or not cite and release should apply, because that's not what the officer was dealing with that day. But looking simply at what the defendant is asking to suppress, none of the applicable legal doctrines would require suppression of those things. The evidence that she saw him driving and his driver's license was revoked, and then he committed a new crime. For those reasons, the state requests that you respectfully deny this motion.
Anything else, Mr. Vaughn?
Yes, sir, rebuttal. Let me hit on the driving on revoked first. The law requires that that once an investigation is ended, that once the reasonable time for an investigation is ended, it should have been ended. It should be. There's video proof that it took up to 29 minutes, which is unreasonable for a stop of that volume, Your Honor. And there wasn't proof of driving on revoked until after the fact. I mean, it's well on into the night. And then there's also discrepancies in the system they're using to say that I'm driving on revoked. It's saying driving on revoked, but multiple times you can look through there and see that the charges are reinstated. And there's also a scene in the video where dispatch is talking to the officer and they're debating on whether my license are actually
Judge,
revoked.
I'm sorry. None of that has come into evidence.
Correct. Sustain the objection. None of that was brought forward in your argument, nor in your evidence, and none of that was played for the court. So I have no evidence to support what you're saying.
Is that not in my motion, Your Honor?
It doesn't matter whether it's in your motion. A hearing such as this is an evidentiary hearing. It's required that you produce proof on every issue to substantiate what you allege in your pleading. Pleadings are nothing more than allegations. So there's nothing in the record today that would support what you're arguing. I sustain the objection.
Okay, all right. And I have to reiterate that for it to be a past act of retaliation, that I have to say something directly to the officer or the victim, Your Honor. And there is not one person or any proof that they can provide that I actually stated something straight directly to anybody. I'm just freely talking. And for it being a new charge, there is no new charge to apply to someone when I'm not talking straight to nobody. And I shouldn't even been placed in a situation to have to even fight a charge if I wasn't even illegally arrested. I should have been cited and released, if anything. I had one more word that slips my mind, Your Honor. That's all I have now.
Right. In considering your motion to dismiss or to suppress, the court has to view all of the evidence that's been produced here at the hearing. The evidence at this hearing is indicated for Officer Corporal Javins has testified to as the reasons for her initiating the stop. of this vehicle were to investigate a domestic violence situation. She approached the vehicle and began speaking with you. She asked you to step out, or the defendant to step out. The defendant refused after repeated requests. Why is that important? Because the court is well aware of the fact that there is a greater risk of violence or threat of harm to law enforcement in response to domestic violence cases than many other kinds of cases. But an officer who is investigating a scene has a right to request that a person step out of the vehicle. Refusing to step out of the vehicle, and according to what we saw, was what you could consider to be some sort of forceful resisting. The argument that there is no valid charge of resisting arrest because it's, of the circumstances, and therefore the fruit of the poisonous tree, so to speak, would apply, implies that there was, or assumes that there was an illegal arrest for that. 39-16-602 of the Tennessee Code defines resisting stop, frisk, halt, arrest, or search. And that under subsection A says it is an offense for a person to intentionally prevent or obstruct anyone known to be a person, to the person to be a law enforcement officer or anyone acting in a law enforcement officer's presence and at the officer's direction from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer or another. Subsection B, except as provided in section 39, TCA 39-11-611, it is no defense to prosecution under this section that the stop, frisk, halt, arrest, or search was unlawful. So it basically says that can be. Now, I understand the argument being made that you are you really didn't do much to resist, according to what you were saying. But there's sufficient case law that would support a finding of guilt, and that's really not the issue, because what we're dealing with is probable cause. Is there probable cause for an arrest? Don't confuse the fact that there is a lower standard for probable cause to make an arrest than there is for a conviction beyond a reasonable doubt, which is what you're arguing. Evidence was sufficient to convict the defendant of resisting arrest because the defendant ignored officers' orders to come out from underneath the vehicle and had to be dragged out. And the defendant then refused to place his arms behind his back so that he could be handcuffed. And the defendant struggled with the arresting officers before his investigator was able to place handcuffs on him. State versus Baker, a 2019 Court of Criminal Appeals decision. The application for appeal to the Supreme Court was denied. And that's found at Lexus, at 2019 Tennessee Lexus 484. September 20th, 2019. So that, and that was supporting a finding beyond a reasonable doubt of sufficient proof for resisting arrest. In this case, the court is only concerned with whether there was probable cause for the issuance of the arrest, because if there was probable cause for the issuance of the arrest for resisting arrest, which clearly by this court's finding there was, then the argument you make about the fruit of the poisonous tree is actually irrelevant because it does not apply. But in any event, the officer had probable cause to stop the vehicle, had probable cause to interrogate the passengers in the vehicle during an investigation for domestic violence. Why require the driver to step out? Because under the circumstances with the type of charge, very easily that a person could have driven away and fled the scene with the victim of the domestic violence in the vehicle with him. Those are just concerns that the court is aware of that could have applied. They ask a person to step out of the vehicle sometimes for officer safety. There is nothing illegal about that. The resisting statute makes it clear that resisting an officer's directions to step out of the vehicle where you have to be dragged out make it a part of the statute. So even though the state is elected not to proceed on that charge, the fact of the matter is that there was probable cause for the arrest on that charge, and therefore even if that charge was dismissed, there was probable cause that existed for them to initiate an arrest in this court's opinion. As to the driving or revoked charge and the argument about cite and release, yeah, if he had stepped out of the vehicle and offered his driver's license to the vehicle without resisting, then he could have been cited and released at that point. The officer had probable cause to stop him and check his license and to check the circumstances during an investigation of the domestic violence, and could have checked his driver's license and allowed him to be cited and released. His actions on that scene, on that particular moment, are the very reason why that did not occur. As to the retaliation charge, this court disagrees with the interpretation that Mr. Vaughn makes of retaliation. 3916.510 of the Tennessee Code provides for retaliation for past action. And it says a person commits the offense of retaliation for past action who harms or threatens to harm a witness at an official proceeding, a judge, a district attorney general, an assistant district attorney general, an employee of the district attorney general, or a law enforcement officer, clerk, employee of clerk, juror, or former juror, or family member of any such person by any unlawful act of retaliation for anything the witness, judge, district attorney general, assistant district attorney general, employee of the district attorney general, or law enforcement officer, clerk, employee of the clerk, or a juror did in official capacity, and so forth. The offense of retaliation for past action shall not apply to an employee of a clerk who harms or threatens to harm the clerk, and that has nothing to do with yours. So the statements that have been introduced at this hearing the other day and today are that the defendant made a statement, got some bullets for all of you after he was at the jail and was upset about being arrested. The other testimony today as he walked into the jail with Corporal Javins was, I'm a threat for a reason. And then it was also testified that as he was trying to take the handcuffs off and be at the jail, that he made a statement, fuck no, I'm going to beat that bitch. This court is of the opinion that all such statements constitute sufficient probable cause and sufficient evidence for the matter to go to the jury on a charge of retaliation for past action. Therefore, the defendant's motion to suppress and dismiss with prejudice as to docket number 336 is dismissed. Now, we have other motions. Those motions are not applicable to the case that's set for trial next week. I will allow Mr. Spratt, if you want to have a moment to talk to your client about arguing those motions today. They would be motions to dismiss as to the other charges. His other charges include docket number 462, 2021-462, an aggravated assault while displaying a weapon, reckless endangerment with a deadly weapon involved in counts 7 and 8. Counts 1 through 6 are aggravated assault. Counts 7 and 8 are reckless endangerment with a deadly weapon. And count 9 is possession of a firearm by a convicted felon. And the additional charge, indictment number 337, 2022-337, he is charged with simple assault, false imprisonment, disorderly conduct, and public intoxication. And then with 2024 CR 142, he's charged with failure to appear. So the question becomes, is the state able to produce the witnesses necessary for a motion to suppress or dismiss as to these other charges? Is your microphone on?
Judge, on 462, I need about 3 different officers. And one is in training, one is driving a truck and might be available by Zoom, but my preference would be just to reset that motion to hear at another date when they can all be present in person.
Well, we have later this month, of course, this trial is set for Thursday.
Objection, Your Honor.
Pardon?
Objection. Availability of witnesses is not a reason for rescheduling.
That's in your opinion. This court's opinion is we've heard the motions today that are applicable to your trial set for Thursday of next week. The fact that we have other motions that are filed that are for cases that are not yet set for trial, this court is of the opinion that it's not prejudicial to reset those motions for another day. I'm inclined to set them on the 29th if you can get your witnesses.
Excuse me, Your Honor. We're still under the Fast and Speedy Trial Act. I put a motion for Fast and Speedy Trial. Part of the act states that is not a reason for a continuance.
I don't have a trial date on your additional charges, but we will certainly assign you a trial date. It's on what I'm suggesting is that you have a trial coming next Thursday on the first of these cases. We can't try all of those cases under the same jury pool for your detriment. It would be detrimental to you for us to bring a jury in out of the jury pool, select a jury, try the cases that we've talked about today, then turn around the next day and that same group of people who now know that, the evidence regarding that charge are then asked to sit in judgment of you. Let me finish. Who are asked to sit in judgment of you. I can't trot in a different jury panel for cases, multiple cases, to try them back to back to back. I'm trying the one that the state has elected to go first. We will then select a speedy trial date for your other charges as soon as we finish trying that one. I would like to see how soon we can set it. And if we can go ahead and set it for a trial either this month or next month, if you can get your witnesses in. Well, this month would require a different jury pool. For that reason, it would have to be next month.
So we're setting a continuance for her witnesses, correct?
A continuance on your motions.
Yeah, that's the same argument. It ain't got nothing to do with the trial I'm talking about. The continuance just for the witnesses to be present is what I'm arguing.
And what detriment to you is there for continuance of the hearing on the motions you filed when your cases that those apply to are not set for trial? How does that prejudice you?
Well, my witness is here today and it just.
She's under a subpoena to reappear.
I understand that, Your Honor, but for her to keep on coming out of her way, then I don't even know if that's possible.
So she's under a subpoena, so it is possible she will have to appear or she'll be in contempt of court.
Is there a way for her to appear on Zoom if need be, Your Honor?
No, not under the circumstances. Well, if for a motion hearing, we might be able to do it by Zoom. Yes,
Yes, that's what I'm asking because the officer's allowed to do it. My witness should be able to
I
too.
think if I allow an officer to do it, she'd have to be allowed to do it as well. And we'll be happy to set that up for her. And she's nodding, that's what she'd like to do. So we just need to make sure that she gives Mr. Spratt her information so that whenever these motions are set, I'm inclined to set the motions on the 29th. General, is there any reason you can't get your witnesses together on the motion for the 29th in the afternoon?
Of this month, Your Honor?
Of this month.
There's a highly probability I'll be in Decatur.
Pardon?
There's a high probability I'll be in Decatur.
High probability you'll be in Decatur.
Judge, he has a circuit court date in Decatur on September the 30th. I don't know when they transport, but that's what he's expressing.
How certain are we that Jimmy Reader PCR is going to go? There's a possibility that we could do the motions first part of October, but I won't know that until after Tuesday of next week. So after Tuesday, the 23rd, I should be able to tell you if we can use the first or second of October for the hearing on the motions. What do you have, General, on those days?
Judge, I would be available that day and I should be able to reach out to witnesses for motions that day.
Then let me determine on Tuesday, after Tuesday of next week, I can tell you if we can have your motions heard as quickly as the 1st or 2nd of October. Right.
Will that be by mail or?
Well, I'm going to have to let Mr. Spratt know first, and then we can notify you by mail if that's necessary. I want to get word to you as quickly as possible.
Okay.
About the order of appointing. Some of this stuff, I'm not sure that I have the order of appointing me, but I don't think I'm allowed to be compensated at all for this.
And we'll enter an order not pro tunc because I'm almost certain I saw an order appointing you.
Well, and Your Honor, the way I read the Supreme Court rule is that Mr. Vaughn being the pro se first chair, that the Supreme Court won't allow for co-counsel. So the order is conflicting there. I believe I did at one point see an order that appointed me as counsel, but I don't think the court ever announced that.
Yeah.
Mr. Flanagan, Mr. Vaughn was here on the failure to appear that was ultimately dismissed. And the court, if I'm not mistaken, appointed me as elbow counsel that day. And then Madam Clerk's office sent a standard appointment order that I never understood to have any effect. I never understood that to have the effect of appointing me. I don't think the Supreme Court's rules allow me as second chair to be compensated in class E, D, C, or even B felonies. I think it requires like a death penalty case or a first degree murder case for co-counsel to be appointed.
You may be right.
And that being the case, I have volunteered since Your Honor's ruling, and I will be filing a motion in another case for Monday to have me designated as lead counsel under that rule in Ms. Stephanie Lowe's stead. But that being said, if I'm not able to be here at some of these dates, I've have quite a bit going on with transitioning into my solo practice and closing out some cases, and I have civil cases and cases everywhere. So I'm not trying to withdraw from Mr. Vaughn, but just say in the hypothetical in the past when Mr. Baker and I have had cases, sometimes he might be here to argue them, sometimes I might be, and I don't mind coordinating a witness for him. It's just that I can't, I'm under an order that doesn't compensate me ostensibly in violation of the 13th Amendment. I like Mr. Vaughn. I don't mind helping him at all, but
I understand. Let me review the file and we'll determine that. obviously, we have a trial next week, and you, it's my understanding you're willing to assist him in that trial.
I am willing to assist him in that trial. Yes,
So
sir.
we'll determine the remaining charges at that point.
Yes, sir.
And it's, the law is it's where Mr. Vaughn has elected to represent himself, that the appointment of advisory or elbow counsel is completely within the court's discretion. He's not entitled to it. It's within the court's discretion. Frankly, reading Mr. Vaughn's pleadings that he has filed, he demonstrates a level of legal expertise that is unusual for a pro se defendant. And therefore, I'm not really as concerned now, having read through all of his pleadings as I was initially, that he's in need of advisory counsel. He seems to be very competent to raise all of the issues he wants to raise. And for that reason, it may be necessary to relieve you if you're not being compensated from representing him further beyond the trial next week.
Yes, sir. I do think he would need, I'm not volunteering per se, but I do think it would be beneficial for him to at least go through his first jury trial before we.
Once he has gone through the first jury trial with you, then the remaining jury trials, he would at least have some experience. So, all right, then we'll.
At that time, I would request for another elbow counsel if possible, Your Honor.
Now, that's the thing, as I just explained. If you elect to represent yourself, you don't have the right or entitlement to elbow counsel. I have the discretion, within my discretion, to appoint someone to help you. Now that you have filed all of these pleadings, and I've seen that you have a level of expertise in raising all of your issues, I don't find that you are necessarily entitled to have elbow counsel. You're representing yourself. That comes with a obligation that you be prepared to do everything that you're supposed to do. So Mr. Spratt will stay with you through this next trial, but I do not intend to appoint elbow counsel to help you with the remaining charges.
I object to that, Your Honor.
I understand you object.
The Sixth Amendment, I believe I'm calling the right amendment, counsel, and as I see fit.
So are you wanting to have an attorney to represent
I'm
you?
still wanting to represent myself. I want to stay lead seat, but with assistance.
And as you heard me state, the Supreme Court's rules are that elbow counsel is advisory in nature only and completely within the discretion of the court. And to appoint an attorney who would have to then stay with you at no compensation, this court is not entitled to do that. You can hire your own lawyer if you want to. This court is not going to appoint an additional elbow counsel. So Mr. Spratt will stay with you. We will see you all on Thursday, if not before. So I'll let you know after Tuesday whether or not the October date will apply, although Mr. Spratt has indicated he will no longer be able to continue. So we're going to break for lunch, and that will conclude this hearing today, and the remaining issues will have to be scheduled for a future hearing. Make sure that that the witness that was here under Ms. Dozier has given the proper contact information, and we'll go from there.